Petition is dismissed.
All right.
May I please your lordship? Lordship, I beg to mention item number 47 with the consent of the other side. Lordship, the conducting council is out of station. Matter may kindly be listed on 9th of December.
Item 47, okay, on the prayer of learned counsel for the petitioner along with consent of the respondent, list the matter. On
Not
9th.
Respondent, petition, we are the respondent.
You are the respondent, the prayer of respondent. Is the matter on 9th of December.
Yes, your lordship.
Very pleased, Your Lordship. Lordship, I beg to mention for listing for Woodall, my lord, tomorrow, my lord. I'm obliged.
Is any order of mine there?
Yes, you order, my lord. Yes, this court order, my lord. Anticipatory bail, my lord, for Woodall, my lord.
What is this court's order?
The CD was called.
CD was called for.
Obliged.
May it please your lordship. Lordship, I beg to mention item number 54 and 55, my lord, on behalf of Mr. H.R.H. Choudhury, my lord. But this matter may be taken after motion matter, my lord, because we have to leave the court, my lord, early. Item 54 and 55, my lord, on behalf of H.R.H. Choudhury, my lord. My senior have to leave the court after 1 p.m., my lord. Kindly take up the matter after motion matter, my lord. I have received the case also.
All right, take it.
Briefly also.
Please, Your Lordship. I beg to mention item number 42, my lord. Kindly adjourn for the day, my lord.
42.
40. On behalf of SC Business, my lord.
Prayer of learned counsel, is the matter on? Give a date.
Bless me.
Hey, please, your lordship. Lordship, I beg to mention item number 11, your lordship. Due to some medical emergency of the conducting council, your lordship. Pass over for the day, your lordship.
Same order, give a date.
Please, Lordship. I beg to mention item number 22, Lordship. Conducting counsel, Mr. M. Hassan is unable, Lordship. Lordship, kindly take up this matter on Monday, Lordship, next week. Item 22.
All right.
Please, Your Lordship. Please, Your Lordship. Lordship, I beg to mention in item number 10, Your Lordship. In item number 10, the informant has filed wakalatnama as well as the objection today, Your Lordship. That may be allowed to be brought on record.
May I please, Your Lordship? Lordship, I beg to mention item 38, mention. Kindly adjourn the matter for the day, Lordship. I mean,
30?
CD was also not received.
PHC did not
Interim is there,
receive
Lordship,
the
that-
matter again, no?
Interim is there, Lordship, that may be called.
Interim order passed earlier to continue till the next date of listing.
18th.
I love Lordship.
I beg to mention item 13, Lordship, on behalf of B. Hussain. He is out of station, Lordship. Let the matter be listed on next week.
Yes, give the date.
Thomas.
I beg to mention item number all for my lord. CD has not been.
41, CD not received, list again, no?
Date may be given. We are not on interim, my lord.
Out of December, Lordship.
One.
एक मिनट बहुत बड़ा हो जाएगा out of December.
May I please, Your Lordship, I beg to mention item number 36. Hearing on behalf of user Sokia, he is not well today, Lordship. Kindly adjourn the matter for two.
We have received the case diary.
Interim is there.
Friday. When do you want? Interim,
December.
interim order first 30 to
February.
continue next.
Thank you, your lordship. In item number 56 of supplement is, we have filed an additional affidavit, lordship, and it may be taken with the record, lordship.
Yes.
Your lordship, my prayer is for listing a criminal petition, lordship. Next week, any date, lordship.
Senior bench, no.
May it please your lordship.
Yes.
My lord, page 9 is the affair, lordship. Whatever, my lord, the petitioner number 1, my lord, has a love affair with the informant's, my lord, uncle, my lord. They went to Dhekiajuli, my lord. Both are major, my lord, then hence this case has been lost, my lord. Page 9 is the affair.
It's different.
They have stated different, but my lord, whatever, my lord, the petitioner number 1, my lord, had a love affair with the informant's uncle, my lord. Well, they went to Dhekiajuli, my lord, to the house of the petitioner number 2, who is the brother-in-law of the petitioner number 1. And my lord, the person has been recovered or not recovered. He was not even kidnapped, my lord, but he was found on that day itself.
Looking at the grounds of arrest, we must have the CD first.
Okay. Or that may be fake news. Oblige your lordship.
May I please your lordship? Lordship, this is the charge-sheeted case, lordship. In the same case, lordship, in the court number 21, lordship, today is the hearing date, lordship. Scan copy is available there, lordship.
Where?
Court number 21, lordship. And maybe short date may be given for hearing, lordship.
When is it fixed?
Lordship.
When is it fixed there?
Lordship, DA number 2899.
When it is fixed? Today.
Today, lordship.
Today it is fixed.
And any date may be fixed, short date, lordship, for hearing, lordship. Scan copy is available there, lordship. Court number 21.
Same CD.
Same CD, lordship. On Friday, lordship, 28.
Is the matter. Friday.
Yes, lordship. And item 3, same, lordship.
When 3 same.
Yes.
So you will have the CD then.
Scan copy of the records. Charge-sheeted case.
Huh?
Charge-sheeted case, scan copy of the records for the court number 21.
21.
So it can
Friday it will be available here.
Yes, sir. Obviously. Item 3.
Is same.
He is same. He is same.
Item 4.
Lord, kindly take the matter after some time. The type of my senior is another courtroom.
Right after some time.
Item 5.
May it please your lordship. My lord, here, my lord, affair at page 9, my lord, it's a charge-sheeted case, my lord. The petitioner was shown as an absconder in the charge sheet, my lord. He voluntarily appeared before the trial court, my lord, and he was taken into custody, my lord. Phase 9 is the FIR, your lordship.
Three 66 and 376 too. Records may be called for lordship, his associated case.
My lord, page 22 is the impugn order, my lord. Order in which he was taken into custody. Page 22. He voluntarily appeared, my lord, before the court, my lord, to face the trial, my lord, but he was taken into custody. With a bail petition, he appeared, my lord, bail was rejected, and was taken into custody. The constitutional court also rejected his bail, and the trial court also rejected his bail, my lord.
So we must have the record then.
Lordship.
Yes. Call for the TCR along with C.
812.
Oblige, your lordship.
Just lordship, my lord, he was arrested on 17/8, my lord. More than today is a 100-day, my lord. So on that ground, my learned friend made often instruction whether charge sheet has been filed or not.
So after tomorrow, lordship, it will be, I want to take instruction whether charge sheet is filed or not, lordship. Just 94 days as per my learned friend service.
Is the matter to tomorrow in order to enable learned additional PP to abstain instructions whether charge sheet has been filed.
Yeah, please, your lordship. Lordship, bail for co-accused lordship out of the same FIR is fixed tomorrow for case diary, lordship. This bail application also made right.
Along with
List again on 26. Along with
lordship. Along with BA number 3599 of 2025, lordship. 3599. 225. BA number. Deeply obliged.
May I please, your lordship? This is a case of, my lord, attempt to rape, my lord. FIR page 7, my lord, annexure 1. Furtherless, my lord, 96 days completed to them.
call for this table.
Statutory period is, my lord,
96 days.
96 days.
Hmm?
Attempt to rape. 96 days, my lord. And it is mere attempt, my lord.
charge sheet.
We have to take instruction whether charge sheet is submitted on his case.
At 2 PM, my lord, kindly. Tag this for me.
You can get the instruction.
Yes, but if not possible, then tomorrow or day after tomorrow.
We'll take up at 2. So see if you can.
এরকম বলো না দিদা আসছে দিছে কথা 150 হ্যাঁ
May it please, your lordship. My lord, here lordship has dealt with the matter earlier twice, my lord. The lordship recollects, my lord, page 15 is relevant portion of lordship's order, my lord. The case, my lord, where the postmortem report and the inquest report, my lord, there was nothing against those petitioners, my lord. Page 15 is lordship's order, my lord. All the other co-accused has been granted pre-arrest bail, my lord. Here regular bail, almost 57 days in custody. Page 15, my lord. A perusal of the PM report indicates, my lord. Page 18 is also lordship's order, my lord. Same thing has been reflected in these order also, my lord. So my here, my lord, petitioner is beyond the bars for 56 days today. In the length of detention and, my lord, The co-accused has been granted bail, my lord.
Who is this present petitioner?
For Baharul, my lord. The accused number one.
Yes, PP, similar.
Yes, the similar matter, the no injuries found in the PM report and inquest report also.
Yes.
No injuries found in the PM report and inquest report also.
Yes. Case 14 order. Case 14, my order. That was in anticipatory. Bid, okay. Accordingly, this is an application. Page 15, second last para. Accordingly, the petitioner named above is directed to be released on bail of rupees 50,000. The security of like amount. To the satisfaction of the learned Elaka magistrate. In connection with the aforesaid case. That petitioner has by now spent 56 days behind bars.
Oblige, your lord. It will be CGM Nagaon, my lord. Or
CGM Nagaon.
Oblige, your lordship.
Hello.
51.
Hey, please, your lordship. Also, will kindly see page number 30 of the additional affidavit. Page number 30. There was a news item on Facebook, madam. It's in the additional affidavit, madam, page number 30. And under this post, my lord, the petitioner made a comment that is fake news. And because of this comment, my lord, he was picked up and subsequently was arrested. And my lord, he has been behind bars since last 13 days, my lord. Other than that, my lord, he has not posted anything else, my lord. Just simply this comment that this news item was fake. These sections which have been, my lord, which by lord, this FIR was registered, my lord, prima facie are not at all attracted, my lord, in this case. The thing which he has done was that he has expressed this opinion that this news item was perhaps fake. And just because of that comment, my lord, he was arrested.
The Delhi Bamlas. Whereas shortage of later CD may be called for lordship.
What will the CD release?
Yes, the CD will not reveal anything else, my lord. Only this screenshot, nothing else.
Learned counsel for the petitioner. Additional PP. This is an application under so and so. Where is the FIR?
FIR is at my lord, page number 17. And the relevant portion is at page number 19.
It appears from the FIR that the allegation against the petitioner that he made a comment that is within inverted comma, fake news, response to a news regarding the recent bomb blast that took place in Delhi near the Red Fort. Where it is stated in the, it is also stated in the FIR that activities indicate his intention to promote enmity between different groups within the society, cause communal tension and disturbances, thereby endangering the sovereignty and integrity of India. The potential to incite communal violence, provoke separatist sentiments among the public. So page 19, okay, see, look. The petitioner was arrested on
13/11.
7. Spent about
13 days.
is behind the bars. Era. But to the head of the allegation. Period of detention. So having due regard to the opinion of the informant as expressed above. Bail is allowed. Bail of rupees 50,000. Like amount. Citizens accordingly.
My lord, regular bail application, my lord, the FIR may be seen at phase 8, my lord. The type copy.
Page?
Page 8, lord. Translated portion, my lord.
Yes.
Now, my lord, what happened? The victim, alleged victim girl, my lord, was the housemaid of the petitioner number 1, who resides at Tezpur, my lord, Balipukhuri, Piniali. On the day of incident, my lord, she was taken to my lord Pasighat for attending her, my lord, petitioner number 1's sister's birthday celebration, my lord. And she was always, my lord, in the mode to escape from the job, as her father and mother, my lord, they engaged her with the petitioner number 1's house, my lord. And it was the impression of the petitioner number 1 that she is 18 years old, my lord, as her parents also told that. My lord, on the day of traveling to, my lord, Pasighat, she was crying in the train station. And seeing that, my lord, one informed the present informant that one girl, she was taken to Pasighat for immoral trafficking like that, my lord. But the actual fact is that, my lord, she was a maid of petition number 1, but that is also, my lord, under impression that she is 18 years. As police stated that she is about 17 years, but my lord, it appears that she 18 years above old girl, my lord. But now 22 days behind the bar and
CD.
both the short date, my lord. Both are women, my lord, they are languishing in jail.
Yes.
512.
Obliged, lordship.
It is your lordship.
Yes.
Sir, to page 11 is the translated copy of the FIR, lordship. Allegation of fund, lordship, by the another person, lordship. My lordship, from the FIR, it transpires that, my lord, the informant himself is the main person behind collecting the money, lordship. Down he has alleges against.
Is there is required in discussion. CD may be called for. Because
Basically, I am a lordship, a member of a Railway Malgudam Shramik Sangha, lordship. Actually, order of that Sangha, lordship. I may be allowed some time to appear before the IO, lordship. I will record my statement, lordship. Some protection may be granted, lordship.
It was earlier rejected after seeing the CD.
In that,
We need to see the CD.
before the session, also he has submitted objection, lordship.
Customs Court has observed it is obvious from the CD regarding your involvement. That is why we cannot pass orders.
912.
Obliged.
I'm appearing for the informant, lord. File the open.
Obliged.
Great legal lordship. My lord, thus informant and my lord, petitioners are all our practicing lawyers of Jorhat Bar, my lord. Now, if your lordship will find 3%, my lord, FIR has been filed, my lord, no doubt there is an extramarital affairs, my lords, between the petition number 1 and my lord, the complainant, my lord. Lordship will find annexure 2, that is at page 13, my lord. That 13, my lord, is an affair, and it resulted on the basis of a notice sent to petition number 1. Your lordship will find the annexure 1 is the notice, my lord. That FIR is resulted to the notice dated 16/10/2025. BNS will not come, my lord, tracking this.
What is the legal notice about?
Yes, about the same thing, the same, my lord, lordship will annexure 1, that page 10, my lord. Is a legal notice to me, my lord, petition number 1, my lord. Lordship, kindly see that the petitioner one and legal notice, my lord, which has been issued on 16/10, my lord. There is a legal notice, my lord. And there is a demand of rupees about 7 lakhs, 7.5 lakhs. In fact, my wife also lodged an FIR, my lord, which I have not annexed, my lord, and it come to later on, my lord. That was it. Regarding this, Vidya. Now, so for the 64 is concerned, my lord, that is by my wife, my lord. And the same story, my lord. My wife is also stated the same story, which in the notice itself, but there's a demand, my lord. Actually, what has happened, it was, my lord,
Your wife has lodged the FIR against whom?
against this complainant.
Threatening part is also there. Lordship.
Yes, PP, what do you say?
My lord, it's very difficult for me also, my lord. Matter will be solved, my lord, amicably, my lord. If they are, my lord, there's an
Heard Mr. P. Boral and counsel for petitioner, learned additional petition. This is an application under so and so. All for the CD. They are having regard to the nature of the allegations. Reflected in the FIR and having regard to the fact that a legal notice has been served by the complainant upon the accused seeking certain amounts as compensation, it is provided that the event of arrest, the petitioner will be released on interim pre-arrest bail of rupees 50,000 with security to the satisfaction of the in connection with the is directed to appear before the IO within a matter of period of 7 days from it is the matter.
16/12.
Verbalize, my lord.
The report was called for. Lordship. We have not received the report. This is one. And so this is the third occasion, Lordship, and no report has been received. On last occasion, Lordship, without fail to receive this. This is why. We say some report there. We said, yeah. The day after tomorrow, Lordship, we will certainly provide the, I will personally communicate, Lordship. More curious.
Learned additional PP praise for 2 days time to obtain necessary instructions. Is taken on day after tomorrow.
Obliged, Lordship, obliged. For admission item.
Like, what is the fellow? May I please, your Lordship? My lord, here, my lord, the petitioner has, my lord, challenged the, my lord, impugn proceeding that your Lordship will find at page 24. Page 24, my lord, this is the proceeding. And operative part, my lord, page 25. With due respect, humble submission, the applicant begs to state that he is the resident of the aforementioned locality. All the accused person are of dishonest nature. In the year 2000, the applicant and accused number 1 got married with the Mohammedan laws and customs. With such marriage, the applicant and the accused number 1 gave birth to male children. Their names are Rajiv Khan, aged about 11 years, Shiraz Khan, aged about 22 years. At present, Shiraz Khan is studying in so Academy, Barpata, BS 6th semester, and Rajiv Khan is studying in class 7 at Sublin Academy, Howley. Soon the marriage, the accused number 1 had been torturing the applicant both mentally and physically. That on 6 months prior to the occurrence of this incident, the applicant gave the below mentioned documents to the accused number 1, and she kept those documents into her custody. But the accused number 1, with ill and advice of the other accused person, stole below the mentioned documents on 7/3/2022 and money and kept at aforesaid residence of the accused person. In a result, which above said children of the accused could not submit their respective documents in their school and college respectively, for which they are not getting some benefit during education. Further, for stealing some personal documents and things of the applicant by the accused, the applicant could not submit some documents at his workplace, and for stealing the documents of the applicant, he cannot take a bank loan with mortgaging his land. The accused person mishelped the applicant with the works, and when they were told to return the documents back to the applicant tried to get the documents and from the accused person who is there is stealing in filing of this case. Now this is the case. Now Lordship kindly see the cognizance has been taken by the learned trial court at page 51. Page 51, my lord. It says, my lord, order dated 19/8/2024. Complainant is absent without any steps. Accused so-and-so is present. By petition number so-and-so, place and alerts on our bail. Are the learned counsel so-and-so. Learned counsel for the accused submit that the accused, upon receipt of the summons, voluntarily appeared in the court today. It is further submitted that the accused is ready to abide by any condition upon her in the event of extending her liberty to corporate. In instant case, the accused person has been LS for the commission of the offence under section 406 IPC. Considering the nature of the offence and committed by the accused, and she voluntarily appeared today in the court, I deem it to be proper, allow her bail prayer. Accordingly, the accused so-and-so is allowed to go on bail rupees so-and-so with a security of like amount on condition that the accused will ensure her regular appearance before the court on so-and-so. Bail petition number so-and-so is stand allowed and it is disposed of. Now, Lordship kindly see the the earlier background of the case, my lord. Lordship kindly see at page, my lord, 12. Page 12, my lord. The petitioner earlier, my lord, has filed 2 petitions before the learned court below, which are pending before the, my lord, appropriate court. Now, page 12, Lordship kindly see the first case, my lord, miss case number 42/2022. It has been filed on, my lord, 22/3/2022 under section, my lord, 125 CRPC. And accordingly, my lord, interim, my lord, maintenance has been awarded, granted to the petitioner, amount of rupees 5,000. That is, my lord, pending. Now, another case, Lordship kindly see at page 15 by the petitioner against the opposite parties. Page 15, my lord. This is, my lord, CRDB case number 63/2022. That has also been pending before the learned trial court, my lord. So, my lord, the impugned, my lord, proceeding that Lordship has already seen at page 24 is a counterblast to the, my lord, earlier 2 proceeding filed by the present petitioner against the opposite parties. So, since the matter is, my lord, posted for admission column today, let it be admitted and be posted for final hearing any convenience day by this honorable court, my lord. That will be better, my lord.
No, if you are we to post it for hearing?
No, my lord, matter may be required to be disposed of because my lord, my important documents in her custody. My child's educational documents is also in her custody, my lord. My service documents is also in her
You are
custody.
not going to direct anything like that to hand over.
The matter may be heard and pass the necessary order. The earlier two case, my lord, Learned Pen refer, my lord, the 125 case, it was pending and I am paying the maintenance. And DB case, he would do the DB case, my lord. It is not pending. He would do the DB case on 2/8/2025, my lord. Due to earlier case, my lord, one complaint pending, this present case cannot be, my lord, washed, my lord. And washing, my lord, 528 inherent power can be exercised only, my lord. This way, my lord, 528 access cannot be, my lord. Legality, the cognizance order, my lord. After examining the witness, my lord, Learned Trial Court has take cognizance, my lord. Just third.
We will hear
37,
the
my lord.
matter because there is some doubt whether 406 will be attracted in this case. Has he converted anything to her own use?
Will my lord decided by the
I mean,
trial court after-
those issues are required to be addressed properly. We'll fix a date. For the petitioner. Still appearing for respondent number, sole respondent. Waited for hearing. Is the matter.
First week of
Second
January,
week of
first week of January, can it be? Madam? Developed.
May it please, your lordship. This case, your lordship. I'm challenging the order dated with page 34, your lordship, 30/8/2024, where summons were issued to the petitioners, your lordship, without notice. Your lordship may kindly peruse section 223, your lordship, of the BNSS. Your lordship. May I read, your lordship?
yes.
Examination of the complaint. A magistrate having jurisdiction while taking cognizance of an offence on complaint shall examine upon oath the complainant and the witnesses present, if any, and the substance of such examination shall be reduced to writing and shall be signed by the complainant and the witnesses and also by the magistrate, provided that no cognizance of an offence under this section shall be taken by the magistrate without giving the accused an opportunity of being heard. Now, in this case, your lordship, initially the opposite party number 2, he has filed an FIR. Subsequently, that FIR was investigated upon and a final report was submitted on 31/7/2019. After that, a protest petition was filed. Now, that protest petition was, your lordship, treated as a complaint. Now, your lordship, before I proceed any further, may I refer on to the judgments of the Honorable Kerala High Court? To be Anthony, your lordship, 2025 SCC Online, Kerala 532. Paragraph 7 and 8. May I read, your lordship?
Yes.
Indeed, a radical change in procedure is brought about by the proviso to section 223(1) of BNSS. Pertinently, in spite of the proviso to section 223(1), making it mandatory to provide opportunity of hearing to the
Paragraph?
Paragraph 7, your lordship.
Yes.
Indeed, a radical change in procedure is brought about by the proviso to section 223(1) of BNSS. Pertinently, in spite of the proviso to section 223(1), making it mandatory to provide opportunity of hearing to the accused before taking cognizance. Section 226 does not reckon the accused's objection at the stage of taking cognizance as a relevant factor for dismissing the complaint. Being guided by the precedents of section 200 and 202 of the code and the plain language of the proviso to section 223(1) of the BNSS, this court is of the opinion that after the complaint is filed, the magistrate should first examine the complaint and witness on oath, and thereafter, if the magistrate proceeds to take cognizance of the offence, opposite of hearing should be afforded to the accused. I am also in complete agreement with the following procedural rule related by the High Court of Karnataka in Basagoda's case. To steer clear the obfuscation, it is necessary to notice the language deployed therein. The magistrate, while taking cognizance of an offence, should have with him the statement on oath of the complainant, and if any witnesses are present, their statements. The taking of cognizance in the section 223 of the BNS should come after recording the sworn statement at that juncture. A notice is required to be sent to the accused as the proviso mandates grants of an opportunity of being heard. Therefore, the procedural deal would be this way. A complaint is presented before a magistrate under section 223 of the BNSS. On presentation of the complaint, it will be the duty of the magistrate concerned court to examine the complaint on oath, which should be his sworn statement, and examine the witnesses present, if any, and the substance of such examination should be reduced into writing. The question of taking cognizance would not arise at this juncture. The magistrate has to, in terms of the proviso, issue a notice to the accused who is given an opportunity of being heard. Therefore, notice shall be issued to the accused at this stage, and after hearing the accused, take cognizance and regulate its procedure thereafter. So it is clear, Your Lordship, that in this order, if Your Lordship may kindly peruse, that notice was not issued to us. Now, Your Lordship, I am relying on the Basagoda judgment is also there, 2024 SSC online, Kerala 96, Your Lordship. Para 11 and 12. The same provision, Your Lordship, I am not reading it. Then Your Lordship, 2019 8 SCC 27. Whether the protest petition in my respectful submission is a complaint. I'm not reading this Basagoda judgment, Your Lordship.
Yes.
It's the same thing. 2019 8 SCC 27. This is Vishnu Kumar Tiwari versus State of Uttar Pradesh, Your Lordship. Now, whether this states whether the protest petition can be treated as a complaint. Now, Lordship, base 47 internal page, para 43. I read, Your Lordship.
Yes.
It is true that law mandates notice to the informant complainant where the magistrate contemplates accepting the final report. On receipt of notice, the informant may address the court ventilating his objections to the final report. This he virtually usually does in the form of a protest petition. In Mahabir Prasad Agarwala versus State, a learned single judge of the High Court of Odisha took the view that a protest petition is in the nature of the complaint and should be examined in accordance with the provision of Chapter 16 of the Criminal Procedure Code. We, however, also noticed that in Kasim versus State, a learned single judge of the High Court of Judicature Allahabad entirely held as follows. In Ibrahim Jha, also what was observed was it was not very clear as to whether the magistrate had chosen to treat the protest petition as complaint. This observation would not mean that every protest petition must necessarily be treated as a complaint, whether it satisfies the conditions of the complaint or not. A private complaint is to contain a complete list of witnesses to be examined. A further examination of complaint is made under Section 200 CRPC. If the magistrate did not treat the protest petition as a complaint, the protest petition not satisfying all the conditions of the complaint to his mind, it would not mean that the case has become a complaint case. In fact, in majority of the cases where a final report is submitted, the magistrate has to simply consider whether on materials in the case diary, no case is made out as to accept the final report, or whether case diary discloses a prima facie case as to take cognizance. The protest petition in such situation simply serves the purpose of drawing magistrate's attention to the materials in the case diary and invite careful scrutiny and exercise of the mind of the magistrate. So it cannot be held that simply because there is a protest petition, the case is to become a complaint case. We may also notice in Virappa versus Bhima Redappa, the High Court of Karnataka observed as follows. From the above, the position that what emerges is where initially the complaint was not filed any complaint before the magistrate under Section 200 CRPC, but has approached the police only where the police after investigation filed B report. If the complainant wants to protest, he is thereby inviting the magistrate to take cognizance under Section 191A CRPC on the complaint. If it were to be so, the petition that he files shall have to satisfy the requirements of a complaint as defined in Section 2D CRPC, and that should contain facts that constitute offence for which the learned magistrate is taking cognizance under Section 191A CRPC. Instead, If it is to simply style as a protest petition without considering all those necessary particulars, then a normal complaint has to contain them. It cannot be constituted as a complaint for the purpose of proceeding under section 200 CRPC. Then complaint is defined in paragraph 45, Your Lordship. Complaint is defined in section 2D of the code as follows. 2D, complaint means an allegation made orally or in writing to the magistrate with a view of two is taking action under this code that some person, whether known or unknown, has committed an offense but does not include a police report. Explanation: a report made by the police officer in a case where discloses after investigation the commission of a non-cognizant offense shall be deemed to be a complaint, and the police officer by whom such report is made shall be deemed to be the complainant. If a protest petition fulfills the requirement of a complaint, the magistrate may treat the protest petition as a complaint and deal with the same as required under section 200, read with section 202 of the code. In this case, in fact, there is no list of witnesses as such in the protest petition. The prayer in the protest petition is set aside the final report and allow the application against the final report. While we are not suggesting that the form entirely be derisive of the question whether it amounts to a complaint or is liable to be treated as a complaint, we will think it essential the protest petition in this case is summing up the objection of the second respondent against the final report. Now, our case is exactly similar. Your Lordship may kindly peruse the protest petition for a moment at page 26. Page 26 of my petition, Your Lordship.
Yes.
I'm reading from paragraph 2 that the police has submitted final report in the above case, that the petitioner has no objection to accept the FIR submitted by the police, that the facts of the case as mentioned in the SR is that the petitioner is the owner of possession of a plot of Tozi land measuring 2 bigha covered by Tozi number 428 situated in Bishnagor Gaon, Moja, Khodia district, Tinsukia, Assam, where he was ready to cultivate the seasonal crop by giving fencing thereon, but suddenly on 12/5/2018, some miscreant criminal trespassed into the said land and then captured the land by fixing a banner of Puberun NGO and demanding that the land belong to the NGO. The Xerox copy of the landed documents are filed herewith for your honor's consideration. That immediately after the said incident, the petitioner lodged an SR before the OC Dhola police station. That the petitioner has submitted photocopies of the documents relating to the said land along with the SR to the police. That after receiving the said SR, police called the petitioner, Nirupam Sonowal, secretary, and Sri Manikanto Sonowal, the president. These are the two petitioners, Your Lordship. Puberun NGO, Dhongiri branch, to appear before the Dhola PS, and according to the petitioner was present and submitted all the relevant documents to the petitioner. After that, police registered a case against Nirupam Sonowal and Banikanto Sonowal and sent the said case to the office of the Deputy Commissioner Tinsukia, bearing case number 51/2018 for trial. But even after receiving the notice, the opposite party members were not appeared before the learned court. The Xerox copy of the said notice dated 14/8/2018 is filed herewith for your kind information. That from the above activities of the aforesaid person, there are sufficient ground to believe that they had criminal trespass the land of the petitioner and tried to occupy the said land. That for the said reasons above, the petitioner is willing to proceed with the case by reinvestigate the case by the police. It is therefore prayed that your honor be pleased to admit this petition and further be pleased to reject the final report submitted by the police and direct the police to reinvestigate the case, and after that submit the charge sheet against the above person, Nirupam Sonowal, secretary, and Banikanto Sonowal, president, Puberun NGO, Dhongiri branch, and to pass necessary order according to for the ends of justice. This is the prayer, Your Lordship. There is no list of witnesses. And even the allegations, Your Lordship, in the protest petition, in my respectful submission, there are no allegations. No specifications, no allegations, Your Lordship. So this protest petition, in my respectful submission, ought not to be treated as a complaint. And this is very clearly stated in Vishnu Tiwari case, Your Lordship. I am also relying on another judgment of the Honorable Supreme Court, Your Lordship. Before that, Your Lordship, may kindly peruse, the closure report was not considered. I am relying on a judgment of the Madras High Court. Para 20, Your Lordship.
Yes.
Paragraph, it is on the third page, Your Lordship. Paragraph, it starts from paragraph 16, internal paragraph, Your Lordship, 16. The next issue that arises for consideration, Your Lordship. 17 useful references there. Paragraph 17.
When a document is
Not-
executed.
Your Lordship, the third page, 1, 2, 3, 1. The third page, Your Lordship. of the
Third
document.
page,
The next issue, or useful reference, Your Lordship, page 60, 17, useful reference can be made by the judgment. For this court, Your Lordship, 18. May I point out, Your Lordship, paragraph, it's not, paragraphs are not properly marked, Your Lordship, but several pages on it. Page 5, internal page, Your Lordship, page 5.
yes,
Stop.
useful reference.
These are, yes, Your Lordship. Useful reference can be made by the judgment cited by the learned counsel for the petitioners. This court in A. Rajendra and others, and its passes state the others referred supras held as follows. When a protest petition is filed by the second respondent questioning the closure report filed by the deputy superintendent of police, so and so, the court below is left with three options. The first option is to disregard the closure report and take cognizance of the final report and issue summons to the accused person. The second option is to accept the closure report and issue refers charge notice to the de facto complainant to enable him to file protest petition. The third option that is available to the court below is to order further investigation of the protest petition filed by the de facto complainant. If the court below wants to convert the protest petition into a private complaint, it is open to the court to do that, provided that the court below had considered the entire closure report filed by the police and it had come to the conclusion that the materials placed by the de facto complaint was not considered by the respondent. Police for the de facto complaint has come up with some further materials in order to substantiate his case. This exercise has not been done by the court below while converting the protest petition into private complaint and taking cognizance of the same. So in our case also, Your Lordship, there is no order. The order does not reflect that the closure report, that is the final report submitted by the court, was considered. Another judgment I'm relying on is Air 2024 Supreme Court 3693, Your Lordship. 3863.
Yes,
Para 9, 10, and 11. Although I'm relying on 9, it talks about Vishnu Thakur, so I'm not reading it, Your Lordship. Paragraph 10 and 11. May I read, Your Lordship? From the perusal of the above opinion of this court, it is also reflected the magistrate has also the liberty to reject protest petition along with the other materials which may have been filed in support of the same. In that event, the complainant would be at the liberty to file a fresh complaint. The right of the complainant to file petition under section 200 CRPC is not taken away, even if the magistrate concern does not direct that such a protest petition be treated as a complaint. That's the point I want to raise, Your Lordship. And then with respect to the summoning of the accused, Your Lordship, I'm relying on the judgment of the Honorable Supreme Court, Air Online 2025 SC 61. The
Yes.
internal page 3, Your Lordship.
yes, para.
Para, Your Lordship, starts at 8. In internal page 3, Your Lordship, I'm reading from the word summoning. In between middle, Your Lordship. In
Yes.
para 8,
Yes, summoning of an
summoning.
accused.
Summoning of an accused in a criminal case is a serious matter. Criminal law cannot be set into motion as a matter of course. It is not that the complainant has to bring only 2 witnesses to support his allegation in the complaint to have a criminal law set into motion. The order of the magistrate summoning the accused must reflect that he has applied his mind to the facts of the case and law applicable thereto. He has to examine the nature of allegations made in the complaint and the evidence, both oral and documentary, in support thereof, and would that be sufficient for the complaint to succeed bringing charge home to the accused. It is not that the magistrate is a silent spectator at the time of recording a preliminary evidence before summoning of the accused. The magistrate is to carefully scrutinize the evidence brought on record and may even himself be put questions to the complaint and his witness to elicit answers to find out the truthfulness of allegations otherwise, and then examine if any offense is prima facie committed by all or any of the accused. Now, Your Lordship, a perusal of the complaint petition makes it very clear that there was no allegation against me, Your Lordship. And the magistrate, in this case, Your Lordship, has summoned us without application of mine. Then Your Lordship may kindly peruse last judgment 2015 AR SCW 3027. I'm only reading one paragraph, paragraph 23.
Yes.
May I read, Your Lordship? The steps taken by the Your Lordship, paragraph 23. The steps taken by the magistrate under section 190A of CRPC followed by section 204 of CRPC should reflect that the magistrate has applied his mind to the facts and statements made, and he is satisfied that there is ground for proceeding further in the matter by asking the person against whom the violation of law is alleged to appear before the court. The satisfaction of ground of proceeding would mean that the facts alleged in the complaint would constitute an offense, and when considered along with the statements recorded, would prima facie make the accused answerable before the court. No doubt, no formal order or speaking order is required to be passed at this stage. The Code of Criminal Procedure requires speaking order to be passed under section 203 of the CRPC when the complaint is dismissed, and that to the reasons need to be stated only briefly. In other words, the magistrate is not to act as a post office in taking cognizance of each and every complaint filed before him and issue process as a matter of course. There must be sufficient indication in the order passed by the magistrate that he is satisfied that the allegations in the complaint constitute an offense, and when considered along with the statements recorded in the start of inquiry or report or investigation under section 202 of CRPC. If any the accused is answerable before the criminal court, there is ground for proceeding against the accused under section 204 of CRPC by issuing process for appearance. Application of mine is best demonstrated by disclosure of mine and the satisfaction. If there is no such indication in a case where the magistrate proceeds under section 190-204 of CRPC, the High Court under section 482 of CRPC is bound to invoke its inherent power in order to prevent abuse of the power of the criminal court to be called to appear before criminal court as an accused is a serious matter affecting one's dignity, self-respect, and image in society. Hence, the course of criminal court shall not be made a weapon of harassment. So in my respectful submission, Your Lordship, the protest petition does not disclose the allegations against us.
Yes.
And as such, the complaint may be set aside. And this order, Your Lordship, per se, in my respectful submission, is illegal because no notice was served upon me, Your Lordship. That is my case, Your Lordship.
Yes, what was the last submission? No notice was served before calling.
Exactly. No notice was served, Your Lordship.
Under 223.
Under 223, the proviso, Your Lordship. 1.
Yes.
But the effect that notice was not issued, my lord, that it stand correct from a perusal of the cognizance order. At page 34. At page 34. You would be correct in saying so. May I read that page 34? 30th of August 24, complainant is present. Statement under 225 BNSS has been recorded of 2 witnesses. Heard the learned engaged counsel for the complainant. Perusal of the statements of the complainant petition supported by an affidavit. It appears that there is a prima facie material of offense under section so and so against the accused persons, namely Nirupam Solwan and Banikanta Sonowal. Accordingly, cognizance is taken under section so and so against the accused person so and so. Issue summons to the accused persons. Herein, the proviso is attracted. Whether or not notice has to be issued, meaning thereby whether it's mandatory in nature or not. So far as the criminal petition is fine. This has been filed invoking the inherent powers of this honorable court. But on this ground, so far as the criminal case is concerned, there can be certainly a challenge to the FIR or to the complaint. There can be a challenge to the charge sheet. There can be a challenge to the cognizance. There can be a challenge to the acquit, and there can be a challenge to the conviction. Herein, if my lord considers the prayer part, they have challenged nothing. Continuance of proceeding per se is not warranted under the jurisdiction conferred under the present 528 or 482 CRPC. The prayer at page 12. Proceedings would culminate in conviction or acquittal. May I read that? In the aforesaid premises, it is most respectfully prayed that your lordships would gracefully be pleased to admit this petition, issue notice to the opposite parties, directing them to show cause as to why the included criminal proceeding in CR case number 3/24 under section so and so of the BNS 23 shall not be set aside in court, call for records, and upon perusal thereof, and after hearing both the parties, the lordship would be pleased to quash CR case number so and so, pending in the case so and so, so and so. There has to be a formal challenge to the order of cognizance. There is no challenge. Without accepting the order of cognizance and without challenging that, whether simpliciter challenge to the process, the criminal case going on is permissible would again be a question of law.
So address that question of law.
Well, this part, he has to challenge an order of cognizance to either have his petition allowed or dismissed. There is no formal challenge. Since it's akin that there is no formal notice.
And that is not his only point.
Missing the second part also. There has to be a challenge. That's also why the second part is concerned. My friend was very correct in relying on the judgment of Vishnu Kumar Tiwari. If my lord would have that for a moment, I'll rely on the same judgment. I invite my lord's attention to paragraph 42. He started from 43, 44 onwards and on 42.
Which one?
Well, 1986. Vishnu Kumar Tiwari versus State of Uttar Pradesh.
Yes.
I'm only on the paragraphs in July.
Paragraph
42. 41, and then we come to 42. May I read? In so and so, the final report was filed, which was accepted by the magistrate, by the simultaneously directed the case to be proceeded as a complaint case, and the statements under section 200 and 202 of the court came to be recorded. In the facts of this case, having regard to the nature of the allegations contained in the protest petitions and the annexures, which essentially consisted of affidavits, if the magistrate was convinced on the basis of the consideration of the final report, the statements under section 161 of the court that no prima facie case is made out, certainly the magistrate would not be compelled to take cognizance by treating the protest petition as a complaint. The fact that he may have jurisdiction in a case to treat the protest petition as a complaint is a different matter. Here is the case. Undoubtedly, if he treats a protest petition as a complaint, he would have to follow the procedure prescribed in sections 200, 202 of the code if the latter section also commends itself to the magistrate. In other words, necessarily the complaint and his witnesses would have to be examined. No doubt, depending on the material which is made available to the magistrate by the complainant in the protest petition, it may be capable of being relied on a particular case having regard to its inherent nature and impact on the conclusions of the final report. That is, if the material is such that it persuades the court to disagree with the conclusions arrived at by the investigating officer, cognizance could be taken under section 191B of the code, for which there is no necessity to examine the witnesses under section 200 of the code. It steps one thing further. What I am on is that the earlier non-requirement of the accused to be heard at the pre-cognizance stage has been done away with the proviso. To be fair, he's correct. Under the present code, which says a pre-cognizance hearing is taken. This is of paramount importance, a paradigm shift, my lord. But going back to the earlier code also, may I reread these lines again at page 47, that is, if the material is such that it persuades the court to disagree with the conclusions arrived at by the investigating officer, cognizance could be taken under section 191B of the code, for which there is no necessity to examine the witnesses under section 200 of the code, meaning thereby the departure of 200 is accepted by the apex court. I borrow it here. The departure of the proviso could be read into if this logic which he is presenting before this court by way of his judgment is accepted. This paragraph is in my favor while it follows as I read on. But as the magistrate could not be compelled to treat the protest petition as a complaint, correctly so, the remedy of the complaint would be to file a fresh complaint and invite the magistrate to follow the procedure under section 200 or 200 read with section 202 of the code. Therefore, we have the view that the facts of the case, we cannot support the decision of the High Court. In substance, it leaves to the learned magistrate concerned, the jurisdictional magistrate, to follow path A or path B. If part B is followed, descending against the complainant, then a fresh complaint comes. Else, even the examination is not required as per the judgment. I read on.
But it is a pre-BNSS judgment.
Absolutely, Milord. What he's relying, I'm
The
on the
proviso that has been inserted by 223 was never in the contemplation of the Supreme Court
correct,
at that
Milord.
time.
What I am relying is this part, that if the material is such that it persuades the court to disagree with the conclusions arrived at by the investigating officer, cognizance could be taken under section 191B of the code, for which there is no necessity to examine the witnesses under section 200 of the code. This part was there earlier. But the Honorable Court says the jurisdiction vested under the earlier code says you can take cognizance without following this part. Only if you dissent, then kindly a fresh complaint should be filed, and then it should go with ahead with all the sections of 202 of the earlier code. Meaning thereby, this part, whether it's mandatory or directory, has yet to be confirmed. It's absolutely the same proposition I'm trying to place, my lord, that true, it says a notice of pre-hearing, correct, nothing wrong with that. And this, the earlier code, when it held good, the earlier law, as I mean, unamended, my lord, unrepealed, my lord, this also required some procedure to be done at the stage of the protest petition being filed. And what it's, the apex court said is that the magistrate can straight away do it without following the other. I go on to page 40, paragraph 46 for a moment. But I'll skip to the next judgment, you know. If I just hand it over, 25 judgment. Of all his inox and all, whatever is relying, I'm gonna read the soft copy, lordship permits. Paragraph 7. What actually was issued of this, I've said it print out. Would my lord have paragraph 7 for everyone? The summoning order. Correspondingly, there must be a form in the code. The summoning order.
Yes.
May I read, Milo? It would be relevant to refer to the summoning order, which reads thus, quote, whereas your attendance is necessary to give evidence in a charge under section so and so of the drugs and cosmetics section 40 against the accused so and so. Now, 8. In the judgment and order of the event that criminal appeal so and so, inox so and so, it reads, it could be seen from the aforesaid order that except recording of the submissions of the complaint, no reasons are recorded for issuing a process against the accused persons. This was there. It could be seen from the aforesaid order that except for recording the submissions of the complainant, no reasons are recorded for issuing the process against the accused persons. In this respect, it will be relevant to refer to the following observations of this court in the case of Pepsi Food so and so, which reads, summoning of an accused is a criminal case, serious matter. Criminal law cannot be set into motion as a matter of course. It is not that the complainant has to bring only 2 witnesses to support his allegations in the complaint and have the criminal law set in motion. The order of the magistrate summoning the accused must reflect that he has applied his mind to the facts of the case and the law applicable thereto. He has to examine the nature of the allegations made in the complaint and evidence both oral and documentary in support thereof, and that would be sufficient for the complainant to succeed in bringing a charge home to the accused. It is not the fact that the magistrate is silent spectator at the time of recording of preliminary evidence before summoning the accused. The magistrate has to carefully scrutinize the evidence brought on record and may even himself put questions to the complainant and witnesses to elicit answers to find out the truthfulness of the allegations or otherwise, and then examine if any offence is prima facie committed by all or any of the accused. This court has clearly held that summoning of an accused in a criminal case serious matter, it has been held that the order of the magistrate summoning the accused must reflect that he has applied his mind to the facts of the case and the law applicable thereto. This court has held that magistrate is required to examine the nature of the allegations made in the complaint in the evidence and both oral and documentary support thereof, as well as that would make sufficient for proceeding against the accused. My lord would now have the order which is unchallenged till date.
Yes, page
34. And I'm making a responsible statement. This order had to be challenged if you challenge the continuation of the process in the trial court. How does it read, my lord? The complainant is present. Statement under section 225 BNSS has been recorded of 2 witnesses. Heard the learned engaged counsel for the complainant. perusal of the statements of the complaint petition supported by affidavit, it appears that there's a prima facie case of so and so accordingly. So the procedure of application of mine is followed. It is not that it is not followed. Only he's on proviso, whether notice has been issued or not, it is not issued. Now, whether that fails the entire procedure, at least the cognizance order had to be challenged, because the judgments of the apex court also say that yes, he has to apply his one and then proceed. And at this stage, he can appear in contest on this. There is no difficulty. But without a challenge to this, the entire case, the criminal petition 590 of 2025 should apparently fail. It cannot stand on a mere statements. There has to be formal challenge. And that would be a lot invoke the jurisdiction of the inherent bar of the honorable court. This is not a writ petition, he's praying for molding of the relief. He has to come straight away with a challenge to the whatever he's being aggrieved with. And then it has to be addressed. Lordship may hear the matter. But I'm only objecting on the interim. It's a contentious issue. There cannot be an interim granted without a formal challenge being made. Any rate, Lordship may hear the matter. We'll bring in more supporting laws from both sides on the formality of the proviso vis-a-vis how the law has developed to this stage. But without a formal challenge, he can have the president.
No, but if we allow it to continue, what is the meaning of this? Prima facie, as admitted by you also, he has not followed the provision laid down by law.
It's on record. But so far a distinction brought in that in case a
That
final
may be
report.
a matter of decision in a hearing, but at prima facie, at least the proceeding is illegal.
Exactly.
If without a formal challenge, his petition has an interim order to effect. Lordship may decide the matter. What I'm on is that.
When the prayer is for setting aside the entire proceeding, the orders passed therein are all are included there.
Exactly. That would be a view, but if the proceedings are challenged, if the culmination of the proceedings and the conviction or acquittal, which is.
Anyway, that is not a decision we are going to make right now, whether your point regarding the necessity of specifically challenging that order when the entire proceeding has been challenged, that is a matter to be left for the hearing. But prima facie, at least even as admitted by you, it falls foul of 223.
Admitting or not, it's on perusal of the order which shows that the reflection of that is not there. But however,
That is also not there. 223 proviso is also not there. Then how can you allow the proceeding to continue at least till the matter is finally heard?
the Lordship has substantially heard the matter, Lordship has decided the matter.
So if we have heard, then you should not be praying for another hearing.
No. What I am on is that on the point of law.
Yes.
Otherwise, it's on record.
Yes, as we have indicated on the point of law also,
but
we are not prima
Lordship
facie
also
satisfied
consider-
by your reliance on a pre-BNSS judgment.
How the Honorable Apex Court dealt with the law as was then and gave the
Yes.
laxity to the.
But we are
consequences
now,
of the law.
we are on now as the law stands. Question is, would the Supreme Court have decided similarly in the face of the proviso to section 223?
I'll leave it to your Lordship. But only my objections may be recorded. That's all.
All right, heard learned counsel for the petitioner. Also heard Mr. as one learned counsel for the respondent. Revision has been preferred. Taking quashment of the proceedings before the learned SDJM Sodia in case number, okay. The revision is petition is admitted for hearing. Third, learned counsel for petitioner and counsel for the respondent on the prayer for interim relief. There are substantial questions of law to be decided. And despite the strenuous objections of Mr. Konik, learned counsel representing the respondent, I am of the view that further proceedings in case are required to be stayed accordingly. Further proceedings in so and so case pending before the SDJM Sodia are hereby stayed until further order is the matter. For records are necessary
Not necessary at all, my lord. May I pray for a date? A fixed, my lord.
is the matter for hearing. When do you want?
Any date,
January.
except first, third, and fourth. December it would be over, my lord. Let them continue there. Because the consequential orders have to be passed now. If it's set aside, that part will address, my lord.
No, I'm asking for December or January now.
December, my lord.
Hmm?
December.
All right, 19.
Okay, nice lordship. Grateful, my lord.
Very grateful, your lordship.
Item 15.
Wait, please, your lordship. In this matter, lordship, the respondent has filed an affidavit yesterday. Same may not be on record also.
They did make the living. Any date.
Is submitted that affidavit on behalf of respondent number 2 has been submitted only yesterday. Hence list the matter for admission on
Next week. Next Tuesday. Tuesday.
What is the date?
second week of January, December.
Obliged.
Obliged, lordship. Interim order will continue. Your lordship. Interim order will continue.
Yes, interim order passed earlier to continue.
Item 54.
It will off.
Just a moment.
I am 54 maybe. No. I am for 54, my
Oh,
lord,
this
and
one
she-
is
my
going
lord,
here.
and friend is 55. Off.
Just record to.
The lordship made both matter take together, my lord. Same affair, one she is appearing 55 and I am appearing for 54. The case is, my lord, actually, I am not married at this way. Today is 45 days, my lord. 60 days is a custodial period, my lord. And this is regarding some forgery and cheating. The present petition item 54, he is an assistant accountant in an hospital, my lord. And is serving as a contractual service, my lord. So his service, our stand is that, my lord, whatever was done, the list is prepared by Asha Karmi. Then it was placed to the accountant office, my lord, and the office has prepared the same, and ultimately payment is made. So anyway, my lord, I am not at this stage because ultimately 45 days already gone. So I am only for the length of the detention, my lord. The rest I leave to your lordship, my lord.
Yes, prosecution.
So in fact, my lord, on last occasion, lordship has heard this matter, my lord, and lordship's query was that, my lord, whether is there any procedure, my lord, what is followed, my lord. My lord, allegation is that, my lord, there is a scheme, my lord, JSY scheme, my lord. My lord, this child, my lord, which was born in a government hospital, my lord, they get some, my lord, 2,100 rupees, my lord, from the, my lord, government, my lord. Now, my lord, the procedure, my lord, I have not found directly from the case diary, my lord, the exact, what is the procedure, my lord. But from this statement of the complainant and other witnesses, my lord, the woman who gave birth to the, my lord, child in a government hospital, my lord, they maintain a register, my lord. Now, after that, my lord, they have to apply before the authority concerned, my lord, for the, my lord, this beneficiary, my lord, being the beneficiary, my lord. Now, the responsibility of this accused person was that, my lord, they verify the documents, my lord, submitted by the, my lord, submitted by the applicant, my lord, along with the register of the, my lord, hospital concerned, my lord. That is, my lord, perhaps their duty, my lord, that is reflected from the, my lord, statement of the complainant, my lord. That they have not properly done, my lord, and that is why, my lord, scam has been committed.
And what about The length of detention,
45
days, madam.
47 days, my lord.
47 days, yes. She is 47 days.
Arrested on 11/10, my lord.
Yes.
An investigation is pending, my lord.
but it will be based on records now.
It will be based on record, my lord. Even, my lord, the accused person also, they have also stated, my lord, that they have, yes, my lord, there are some irregularities on their part, my lord.
All records seized by this time also. That documentary evidence.
But Mr. HRS Chaudhary learned additional decision application under so and so. The additional district magistrate Morigaon lodged an FIR on 10/10/25 before the Morigaon PS alleging inter alia. Paragraph 3, last line of continuing. Departmental inquiry, again, Permanent additional PP. Perusal of the CD submits that as it appears from the statement of the complainant, the role of the petitioner is to verify the documents
For processing their,
submitted.
my lord. Before processing their request, my lord.
Documents before processing the request for granting benefits under the ASY scheme. The petitioner was arrested on
10/11, my lord.
10,
So,
11.
11/10, my lord.
11/10.
10/11 arrested, 11 forward.
By now has spent about 47 days in custody. And since the case appears to be based on documents which have already been seized, further detention of the petitioner would be necessary, although the investigation is still ongoing. With regard to the above, the prayer for bail is allowed. The release
CGM Morigaon.
50,000 once. What about next
Morigaon.
item?
CGM Morigaon.
Item number
Is the
50. Arrest that is 10/10/25.
10/10/25, rest is same.
Same.
My lord, there, the Tulukko Deka, my lord, the item number, he is the, my lord, block account manager of Civil Hospital Morigaon, my lord. And my lord, this Rubin Alam, my lord, he is the office assistant, my lord.
We are not saying, we are just saying the role is limited to verifying the documents.
But both the person is equally responsible, my lord.
Yes.
Verifying the documents.
Rest will remain same. Okay. Date of arrest is 10. What? Date of arrest is
10/10/2000.
10/10/2000.
Yes, same. All right.
Deeply online. Hearing. Item 16.
Well, I was granted interim bail, my lord, on the ground of not issuing 35(3) notices, my lord. I was arrested on the same day because earlier they, your lordship has called for the, while granting interim bail, my lord, call for the case that whether to look into that whether
Received.
35
Did not receive, my lord.
Not received.
For some time, my lord.
CD not received. This matter on again on interim order passed earlier shall continue till the next date of listing.
All right.
May I please, your lordship?
My lord, I was arrested in this case and shown arrested, my lord. And because of the non-following of the some of the procedure, I was granted, my lord, interim bail, my lord. On 21/8/2025. Since then, I'm cooperating with the investigation also, my lord. Probably my further custodial detention is no longer necessary, my lord. Since 21/8/25, my lord. And the interim order details, interim order has been passed, my lord.
What is the case about?
The case about, my lord, giving some jobs, my lord. And for that, my lord, taking money, my lord. That's the allegation, not the public servant, my lord. In railway, my lord, go down, my lord, some laborers, appointment of laborers, my lord. The interim order, my lord, dated 21/8/25, my lord. Detailed order has been passed, my lord, while granting the interim because of the 48 notice was sent through the WhatsApp, my lord, and the previous arrest, my lord, it was not indicated. Previous case is pending that, and he was arrested when he was granted bail in the first case, my lord, immediately from the in front of the jail, my lord.
So now he's in.
He's now out, my lord. Interim bail was granted, my lord. Because initially he was
So
arrested.
in both cases, he is on bail now.
Yes. When he was granted bail in the first case, he was again picked up just in front of the jail, my lord, but without following the due procedure, my lord. In the first case, there is no mention that the one more case is pending, which is required under the law, my lord.
Yes, PP.
So already he is in custody.
He was released on technical ground. You only have to show that that ground is not there. You have complied.
In the technical ground, I have not gone through lordship, but lordship, I have gone through the materials part lordship. Materials part lordship regarding if you go by the materials of the CD lordship, here sufficient materials are there lordship, because lordship, the person who and the present petitioner, he has made an union lordship regarding of railway lordship, and thereafter lordship for enlisting in his union, he collected 30,000 rupees per members. Thereafter, what he has done lordship, he used to do some collecting some. He engaged those persons in collecting persons for.
I think we have
job.
dealt with some similar cases.
So lordship, each and
As far
every
as the
case,
present case is concerned, that is the observation of my predecessor who have granting interim order.
Then that is on 21/8/25, my lord. Thereafter, we have appeared also, and we are cooperating with the investigation also.
one more thing is that lordship, he has aspired an objection lordship that I have flagged there lordship. In objection part lordship, there is a direction from the honorable court below lordship that lordship he will not leave the jurisdiction of the court, but thereafter lordship he has again visited to the Manipur and other states lordship. That is their lordship. So lordship, if he is violating that terms and conditions, and apart from that lordship, there are witnesses lordship who has stated lordship, given his statement lordship, that he has been picked up. He was picked up. He was locked in a vehicle. Thereafter, he has been assaulted. So why you are informing all this to the police lordship? So lordship, the entire thing is lordship, he is doing lordship hampering and tampering of the witnesses lordship, and violating the criteria or direction of the honorable court below, and that is also the major issue lordship. Release on bail, then lordship, what he can do lordship, because lordship, this is not only 2-3 persons lordship involved lordship in this case lordship. A huge racket is there lordship, and a huge numbers of persons are collecting money from huge person lordship, not 10-20 lordship. Lordship will lordship, I have flagged it lordship.
At this stage, I am not on the factual part, my lord, because the interim was granted as there is an absolute violation of the procedure they needs to follow while arresting the person.
Yes, lordship.
And if there is violation is itself there, They cannot arrest me, whatever the material, my lord. They have to come for the cancellation first.
You have to deal with the findings of the court as reflected in paragraph 15 of the order dated 21/8, whether those lacunae that have been mentioned in that order are negated by the materials available in the CD, the technical aspects regarding notice and etc. And point out what is there.
Apart from that, Lordship, when person is being allowed to go on bail by this honorable court, Lordship, and subsequently imposing some conditions, and he has violated that conditions, that will
On
also
that, there is a separate procedure.
Yes.
We can't straight away just look at your CD and say he has violated the conditions and cancel. The cancellation is a separate procedure. So you go through what are the notices and all what you have issued, point it out. Flag mark and give it to us.
My contention is that too, my lord, that when there is a first arrest, my lord, in the forwarding report, only there is a mention of the police case, my lord. But why his arrest is necessary, that was not mentioned as per the judgment of our High Court as well as the Supreme Court. That has to be reflected if there is any previous cases pending. That was not reflected in the forwarding report. And the second part is that the notice under 48 of the BNSS that was forwarded to the wife, much delayed in it, that through WhatsApp. And the second notice which was forwarded to some unknown person, my lord, who is not related to me at all. That is on that two ground, the interim was granted, my lord. And thereafter I am cooperating, and these allegations for the first time they are coming across.
Basically 48 and 35.
48, basically. It's a, my lord, the need to arrest. There's a judgment of the Supreme Court that if there's a previous case is pending of the same person, that has to be intimate to the court concerned in the bail proceeding, my lord. In this case, I was arrested in one case, my lord. Then in that particular case, in the forwarding case, there's no mention about any previous case, my lord, which is pending. But when I was granted bail in the first case, next day again, they have arrested from the jail, showing that there is one more case is previously pending. That cannot be, my lord.
What is the decision you are referring to?
That is the decision, my lord. There's our High Court. Lord, you kindly see it. Paragraph 23, madam. There is a Supreme Court judgment also, my lord, to that effect. Paragraph 23. Secondly, when this court has granted bail in the Pasighat PS case number so and so, the court was not informed that accusers also wanted in the Basar PS case number so and so and Itanagar PS case number so and so. Even the learned judicial magistrate first class Pasighat, who has passed the consequential order dated 19/11/14 following the bail order of this court, was not informed that this Tapan Datta was wanted in those cases where he is in accused. It is stated that in affidavit, the Tapan Datta was arrested in the Pasighat police on requisition of the Basar police outside the court on so-and-so at about 4 p.m. He was handed over to the Basar police on so-and-so, who was in turn produced the accused before the magistrate on so-and-so date, which was again beyond 24 hours of the arrested so-and-so. Arresting an accused in a different case from the outside the court where he was granted bail without disclosing the court about the need to arrest him in another case is wholly unacceptable, my lord. So exactly same situation, my lord. There's a one Supreme Court judgment also to that effect. Paragraph 5, my lord. Mr. Kacha stated that
asked that the petitioner was enlarged on bail in pursuance to the order passed by this court on March 2, 2081, but they were subsequently arrested for some other offences alleged to have been committed by them prior to March 2, 2018. We are quite amazed at this statement that we should have expected that if the order of the bail by the authorities of the state is considered to be fit to arrest any petitioner for others offences, it was their bounden duty to apprise the court before taking this petitioner in custody, especially when no disclosure was made to us when we passed the order of the bail that any case or cases under the investigation against any of the petitioner. We regret that this is elementary courtesy to the court was not shown.
So similarly, my lord, my case also, he was arrested initially in the Unmati PS case on 8/8/25, my lord. And he was forwarded to the police station, my lord, on 10/8/25, my lord. Then again, the bail was granted, my lord, on 10/8/25 itself on date of production. Then again, he was arrested on 12/8/25 in a case.
He was released on
12/8/25 in a case which is pending before the Chanmari, which was registered on 8/8/25, my lord. So both the Nunmati PS and the Chanmari case, both are registered on the same day. But while I was produced in a Nunmati case, the information regarding the pendency of the Chanmari case, that was not intimated to the court. And the reasons for need to arrest. That is the judgment of Justice Ujjwal Bhuiyan. Not only in information, they have to also indicate reasons for need to arrest. So on 12th in Chanmari, I was arrested, my lord. But case was registered on 8.
The reasons for need to arrest is which judgment?
Kamal Doctor's judgment, my lord. Paragraph 23, my lord. Last paragraph.
23.
Yes, last line, my lord. Last two line, my lord. Arresting the accused in a different case from the outside the court where he was granted bail without disclosing the court about need to arrest. Why my custody is required. That is the requirement of the law.
To the court.
To the court. That there is one more case is pending and he may be arrested and required in that case also. That was not there. So Kamal Datta was in this case considered to be a free man. That is the word used by the. And in our case, the 40 was, there are 248, my lord. One was forwarded through WhatsApp, which was, my lord, the subsequently Supreme Court said that the WhatsApp messages can't be considered. And the one messages to some unknown person, my lord, who is no way connected to me, my lord. Not I am authorized also. I don't know even.
Right, to mark the relevant papers in the CD.
Obliged. There's a one judgment also in the record, my lord, regarding the WhatsApp messages, my lord.
Yes.
That's there already.
Remember.
Item 18.
Yes, my lord. On the last occasion, your lordship was pleased to call for the scan copy of the trial court records. Now, so far as matters concerned, my lord, charges have been filed, and the charges, my lord, I have been charged under 61-2 and 3-5, the common intention and conspiracy. But so for the allegation in the FIR is about 70. Now it has gone even in the man accused. Man accused is a CCL, a child conflict with law, and he has been charged under 61-2, 3-5, 74, and 75.
This application is on behalf of Rubison.
My lord, Rubison Mayangbab.
Who is the CCL?
The rest of the 4 persons, there were 5 altogether, all are CCL. They are all, and I'm the only one who's aged about 20, 21. And I'm not a man accused. And my lord, if I respectfully take my lord to page 12 of the FIR of my application, page 12, my lord, if your lordship is found, I would like to inform that on 39/2025, my neighbor Sanem invited me to a party named Alex Wahangbam, Oscar Swenso, Rubishan Mayangbam. I'm here. I Swenso, a visit. After having a couple of drinks, I went inside my room and took my bipolar medication in the presence of Alex Wahangbam, Swenso, which I passed out. When I woke up in the morning, I saw Oscar was stop on me, Swenso. And I also suspect 4 of the accused took turn and Swenso, me, Revision, Swenso. I've been naming this.
Yes,
matter.
PP, what role is attributed to this fellow in the charge sheet?
In the charge sheet, my lord, in the charge sheet, I have been only charged under 61-2. My lord, only I have got the front page, which 61-2 and 3-2. That is conspiracy and common intention. That has come. Not in the participation, my lord. I have already languished behind the bar for the last 67 days. I'm a student undergoing B.Pharm in downtown university, my lord.
On 22/10/2025, my lord, searches submitted, my lord. And my lord, white order dated, my lord, what has been, my lord, reflected from the scan copy, my lord. 12/11/2025, my lord, cognizance is yet to taken, my lord. Only that receiving the, my lord, search sheet, my lord, that has been reflected, my lord. Cognizance is yet to taken, my lord. And regarding the materials, my lord, Lordship may kindly, my lord, peruse the scan copy of the record, my lord, the 183 and 181 statement, my lord.
Medical does not reveal much. Any injury, medical. No injuries, no signs of recent.
Her statement was that, my lord, she became, my lord, after taking some medicine, and my lord, my lord, she became, my lord.
No, so far from her statement, as far as the present petitioner is concerned, he was present, he was there in the party, he had entered, but when she woke up, she only found this Alex, and later from some chat, she got the idea.
That is,
But
that is there.
where is that chat?
My lord, any condition may be imposed always at trial, my lord.
Not mention about that in her 161. The learned counsel, Mr. Swain's learned counsel for the Rajay Burwal learned additional PPDC application under Swain's PCR as called for has been received. It appears that charge sheet already been submitted in the case and as against the present petitioner section. Which section has been invoked?
61(2) and 3(5). (61)(2) and 3(5) of BNS.
(61)(2)
subsection 2 and section 3 subsection 5 of BNS.
Subsection 2 relating to being a relating to criminal conspiracy and 61 and
3(5) common intention.
Read with section 3 within bracket 5 BNSS. BNS. Where from it appears that no role in commission of rape upon the victim is attributed to the petitioner, present petitioner. The statement of the victim recorded by the IO does not reflect such involvement either. Regard to the above, as well as the fact that the has how many days?
67 days.
7 days in custody. as well as the fact that he is a student. Therefore, bail is allowed. And so shall be released on bail of rupees 50,000 with securities of like amount to the satisfaction. Learned Elaka Magistrate in connection with the aforesaid case. It is further provided that the regularly appear at the trial if one commences shall not try to influence or intimidate the witnesses in any manner. Stands alone.
Obliged, my lord.
Please, your lordship.
Yes.
Lordship, the present petitioner lordship behind the bars lordship since 23/5/2025 lordship. Associated case lordship, commercial company lordship, NDPS. Lordship, as per allegation lordship, 618 grams of suspected heroin was recovered from the possession of the present petitioner lordship. Thereafter lordship, after completion of investigation, the investigating agency has submitted the charge sheet lordship, and the charges are framed under section 21C of the NDPS Act lordship. So in this present petition lordship, the only ground lordship we have taken, that is lordship 46 violation of 47 and 48 of the BNSS lordship. Article 22(1) of the Constitution of India lordship. Lordship may peruse the.
What is the date of arrest?
The notice lordship.
Date of arrest?
23/5/2025 lordship. New case. Lordship, we have annexed the notice lordship.
It is here.
Yes,
And
my
the
lord.
case, lordship.
Where is the arrest memo is there?
Lordship, notice under section 47 is page 37 lordship.
Yes, 47, 48 we have seen. There is non-compliance.
Yes, Lord.
Grounds are not mentioned.
Lordship.
Anything else to which there is only mention? Communication of grounds.
Yes, memo lordship 39, we have page 39. That is also there lordship. There is also not the grounds of arrest lordship.
No grounds of arrest there also. What was his role in possession?
Yes, lordship.
He was, my lord, he was caught, my lord, with conscious possession, my lord. Commercial quantity 618 grams of heroin, my lord.
50 sub cases was recovered. In this case, lordship, we are relying on lordship Bihan Kumar lordship and Prabir Purakasta lordship. Grounds of arrest has to be given the accused in writing lordship with the basic facts lordship.
But learned counsel for the petitioner, learned petitioner, PP. This is an application under so and so.
We're disposing of, my lord. We're disposing of this application, my lord.
Yes.
My
What,
submission may be recorded, my lord.
yes, what is your submission? That is what we are waiting for. What is your submission?
No, my lord, I thought that the lordship is hearing him, my lord.
All
Anyway,
right.
my lord, my submission is that, my lord, my lord, contraband is, my lord, commercial quantity, my lord, and it was recovered from his possession. As far as, my lord, the grounds of arrest is concerned, my lord, whether, my lord, any, my lord, prejudice has been caused or not, that has he has to show, my lord. Because he well know, my lord, for what purpose he has been arrested, my lord. He was arrested along with the contraband, my lord. This is the first instance, my lord. This is knowledge to him, my lord, that he has been arrested for what purpose, my lord. Now, my lord, that was the procedure followed, my lord. Earlier, my lord. Then, my lord, grounds of arrest, my lord, only the case number and section has been mentioned, my lord. Just like,
Where
my
is the
lord, you
TCR?
will know about the, my lord,
TCR,
case.
where is the TCR?
This TCR is there, my lord.
With regard to prejudice, Lordship, a clear direction, Lordship, in the Bihan Kumar Lordship, that grounds of error should be given in writing, Lordship. And the prejudice, it is what which was then in Darshan Lordship, that will not follow because Lordship, division bench of our court Lordship has decided earlier, Lordship, once there is a contradiction between two judgment of the Supreme Court Lordship, the earlier one should be followed, Lordship. In this regard, Lordship, our High Court Lordship recently granted bail, Lordship. I have few bail orders, Lordship. I may submit. This- Even in the notices, Lordship, there is no whisper of grounds of errors, Lordship. Really earlier format, Lordship.
This is oral information as reflected in the order of the magistrate.
Yes, Lordship. With this regard,
This is
Lordship,
there, my lord. If Lordship allow me, my lord, I'll go to the scan copy again, my lord.
All right, go through.
Let's come tomorrow, my lord.
All right. List on the prayer of learned additional people, list the matter tomorrow in order to enable him to go through the scan copy of the TCR.
Item 20.
deeply obliged, my lord.
20, my lord, search is submitted.
Already 46 days behind the bar, Lordship. In fact, has only received the stolen articles, Lordship, and the main accused persons have been already granted. The Lordship peruses the forwarding report for a moment, Lordship. Stated at grounds of arrest, number 2, the arrest accused paid an amount of rupees 30,000 to receive the stolen property, which was paid to the accused Zagesh Das. Now Zagesh Das is on bail, Lordship. Transaction of 27,000 made through GPay has been collected during the investigation. And number 3, arrested accused have been named previously by arrested co-accused and as the person who received the stolen articles. The person who deals with rags, Lordship. 4-person, Lordship. Behind bar for 46. Fine, Lordship.
It was granted to others after perusing the CD, seeing their involvement or otherwise, and their detention was also 56 days. This case, we have nothing before us now. What is your involvement?
Lordship. Mine was.
Where is the forwarding report?
Forwarding report is at page 14, Lordship. At grounds of arrest, at number 3, I have received the stolen articles, Lordship. An amount of 30,000 was paid to me, which was already recovered by investigation agency, Lordship.
Altaf Hussain.
Altaf Hussain, Lordship.
So recovery was made from your place.
Yes, Lordship. Recovery is already made, Lordship. It's the trial, Lordship. In the length of detention, I may be granted bail, Lordship.
Yes, PP.
Arrested case, madam, now. Material has been collected against him, madam. That is a submitted search. Let him approach the trial court.
Or the scan copy may be
And copy, all right.
short date, Lordship.
It is submitted that charge sheet has already been submitted by CS number so and so.
Search sheet number 68/2025, dated 30/10/2025.
For the scan copy of the TCR along with CD.
Yes.
Twenty-one.
May I please, as your lordship? My lord, a regular bail application, my lord, along with the sections of 61 to 147, 148 of the BNS, my lord, the unlawful activities of the Prevention Act 1967, section 18 and 19 had also been added. I beg to draw my lordship's attention to page 12 is the FIR, my lord. My lord, case diary was called for, perhaps it is available, my lord.
Is there is in?
May I read over the FIR, my lord?
Yes.
To the officer in charge of the Sipsagar Police Station, General Diary number so-and-so, subject FIR, sir, on 19/9/25, a reliable information was received at this police station that Yunus Tamuli of Sipsagar Police Station area is in constant communication with a veteran criminal, Biman Bora, who has a history of involvement in a number of heinous crimes under the Unlawful Activities Prevention Act, as well as in the crime against property, such as the automobile theft. The said individual about whom the secret information has been received is reportedly making arrangement for the purchase of a pistol, hand grenade, and stolen motorcycle from the said criminal. It has further come to light that after procuring the such illegal arms and explosive, the same may be used for carrying of terrorist activities in Sipsagar and other parts of Assam, thereby disturbing the peace and public order. The intention behind the procurement of these weapons and explosive appears to be to destabilize the security environment of Assam. It is also pertinent to mention that the Sipsagar district has previously witnessed terrorist activities such as the grenade blast, kidnapping, and attacks on the civilians, as well as the security forces, which has facilitated through illegal weapons and explosives. If such arms and explosives are infiltrated into Sipsagar, there is a grave possibility of their use against the general public, leading to the loss of innocent lives and destruction of the public and private property. Reliable inputs have been received that the said person, Yunus Tamuli, in association with Biman Bora, who has a link with Alpha Independent, as is revealed from his involvement in earlier case under UAPA Act, and others are acting in connivance with the band Alpha I to carry out the sabotage activities in Sipsagar district by purchasing arms and explosives. The above facts discloses the commission of a serious cognizable offences under the BNS, UAPA, and Explosive Substances Act. In particular, the acts of Yunus Tamuli established conspiracy, attempt, abatement, and preparation of the terrorist acts under Section 18 of the UAPA Act, association, assistance, and support to a person linked with a banned terrorist organization so-and-so, thereby attracting Section 19 of the UAPA Act. Therefore, it is requested that a case be registered immediately and taken up for the urgent investigation to apprehend the accused persons, prevent the use of illegal arms and explosive, and ensure that the safety and security of the citizens of Sipsagar in the particular and the state of Assam in general. So, my lord, petitioner before my lordship is Yunus Tamuli, my lord. He is not Biman Bora. my lord, prima facie from this FIR, my lord, it can be, my lord, this FIR has been structured in such a manner, my lord, it has been mainly basically targeted to Biman Bora, my lord. Now, along with the Biman Bora, allegation is that I am aiding, attempting to purchase some explosive from this Biman Bora, my lord, which is absolutely incorrect, my lord, which I can demonstrate before my lordships, if my lordships peruse the seizure list, my lord, because I have already been arrested, my lord, basing on this FIR on 19/9/2025, my lord. So I beg to draw my lordship's attention to the, my lord, seizure list, my lord.
Yes. Pen drive.
My lord, yes, my lord. My lord, may kindly turn to page 21, my lord. Annexure 3, Koli. I, Sri Dipankar Sutia of Sipsagar Police Station, do hereby seized the below noted articles documents from the possession on being produced the house premises of Srimati Ujjal Hanse, son of so and so, in connection with the above reference in presence of the undersigned, independent witnesses, date and time of seizure of so and so, place of seizure, one seizure list so and so in connection with so and so, Caesar witness Dipankar Sutia, my lord, this has a link with the, my lord, next page. My lord, may be pleased to find at page 23, my lord. One pen drive scan disk of 64 GB containing one audio and one video along with certificate under section 63(4)(c) of the, my lord, this BSA, my lord. So, my lord, signature of witnesses, this pen drive, my lord, has not been seized from the present petitioner, my lord. If my lord may be pleased to find that do hereby seize the below noted articles oblique documents from the possession on being produced oblique house premises of Sri Anush Kumar Gogoi, so and so in connection with the above reference.
But you have featured in that pen drive.
My lord.
You have appeared in the video in that pen drive.
My lord, it is what is there in the pen drive, my lord, it is not.
Is the forwarding report.
My lord, that has been stated, but my lord, maybe, my lord, that video or in connection may be there with some persons, my lord, but the prima facie allegation, my lord, against me, that there is no any act had been committed
Yes,
by
where is
me.
the material PP against?
My lord.
Against this person, my lord, they are, my lord, with Biman Bora, my lord, they are preparing some, my lord, to do some activities, my lord.
Who has said
Double
that?
stick, my lord. And lordship, my lord, I am not reading this, my lord, the conversation, my lord, it is a part of the case diary, my lord. Open court, I'll place it before the one lordship, my lord. What is the conversation going on between them, my lord?
In WhatsApp,
Mobile.
According to Paisa, no?
This is the material.
No, my lord.
We'll take some time to go through all of that.
My lord,
Secondly, my lord, the Biman Bora, my lord, police is searching him, my lord, he is absconding, my lord. That person is yet to arrest, my lord. So at this stage, my lord, I am opposing this bail plea.
my lord, may I pray, my lord? My lord, this section 18 and 19 had been added in this case, my lord. In no way, my lord, from the ground of arrest and whatever the material has been collected, my lord, it is no way, if my lord allows me to read over the provision of section 18, my lord. Or if my lord is allow me to go on bail, my lord, under the strict conditions, because this UAPA, my lord, is not a.
Right, we'll go through the CD and examine if UAPA is attracted here.
My lord, that's why, my lord, the
Material to
section,
connect.
my lord, section 18 says that, my lord, that the punishment for conspiracy, my lord, may I be permitted to read over, my lord? It says that whoever conspires or attempts to commit or advocate, abets, advises, or incites directly or knowingly facilitates the commission of a terrorist act or any act preparatory to the commission of a terrorist act shall be punishable with imprisonment for a term which shall not be less than 5 years, but which may extend it to imprisonment for life and shall also be liable to fine. Now, my lord, prima facie, from the, my lord, the narration in the FIR, my lord, does not constitute that this section can be attracted, my lord. Secondly, my lord, section 19 has also been added, my lord, which is more relevant. Punishment for harboring. Whoever voluntarily harbors or conceals or attempts to harbor or conceal any person, knowing that such person is a terrorist, shall be punishable with imprisonment for a term which shall not be less than 3 years, but which may extend it to for life and also liable to fine. So, my lord, there is no question of harboring.
Harboring here.
My lord, it will not attract, my lord. So, therefore, the Honorable Apex Court, my lord, has recently and they categorically dealt with, my lord, a very 2025 judgment, my lord, wherein this section 18 and 19 has been categorically dealt with, my lord. If my lordship may be pleased to allow me to read over, my lord, this few paragraphs, my lord, which is arising out of a judgment delivered by the Honorable Karnataka High Court, my lord, wherein the Honorable Karnataka.
Pass over the judgment, we'll see.
My lord, my lord. So, my lord, my respectful submission, my lord, is that from the seizure list also, my lord, that there is no any explosive guns or any incriminating material which can attract these provisions has been recovered, my lord. So, therefore, my lord, under strict conditions, my lord, as I am a, my lord, by profession, I am a journalist, my lord, and I am advocating for some of the down-to-road persons, my lord, in the Upper Assam districts, my lord, has recently have also established a organization under the name and style as Baghana, my lord. Immediately after this establishment of this organization, my lord, this affair had been lost, my lord. That is the reason, my lord. Highly obliged, my lord.
Well, you see, my lord, I have paid for some time, my lord, to produce the case diary, my lord.
My lord, this is the, I have been in jail, my lord, since 78 days. Earlier also, my lord, the zone of arrest, my lord, I am the father of a son. The son committed the offense. My plea, my lord. Even in the FIR, it is revealed that son committed the offense.
That one, yes.
Short
That
death,
one,
my
my
lord.
lord. The last occasion also, this short time, my lord.
On the short death, I am praying for very short death, my lord.
78 days, my lord.
Today is, my lord, 25, my lord. I am praying for 3rd of December.
Today, my lord, 78 days, my lord. 59 years old man, my lord. Been in jail.
I have
And even
paid
in
for
the
some
FIR,
time.
my lord,
I am sorry.
it is clearly mentioned that my son has run away from that place of occurrence. This is the statement of the complainant, my informant.
Your son has run away. Where is the statement?
Yeah, statement, my lord. FIR, my lord. Kindly see the FIR. May I read, my lord? In middle, my lord.
Yeah, we have seen that earlier also.
After hearing hue and cry, I rushed to the spot of incident and found him lying on the ground filled with blood. Moreover, I have seen Shanu Das Chaudhuri, son of Kumresh Das Chaudhuri,
running away with that blood-filled sharpened weapon from the spot of incident. Shanu Das Chaudhary is that committed the offense, my lord. The victim is the friend of Shanu Das Chaudhary. I am not Shanu, my lord. I am the comrade Das Chaudhary. I'm saying that my son has some altercation with that victim and they were gossiping, some friends were gossiping under a banyan tree, man. And from that altercation, the incident took place. My son has run away and subsequently my lord took shelter at my home. On reaching home, I being the father, he ran away from the house.
Sufficient time has he has been behind bars now. 78. Learned counsel for the petitioner. Yes, called for has not been received.
Submission may be recorded by the diocese.
Learned PP, additional PP, Mr. RJ Borua, praised for further time to use the CD. The second occasion that the IO has failed to produce the CD. There are the allegation against the petitioner. Allegation as reflected in the FIR is that while the son of the informant, son or nephew?
Nephew, my lord.
Nephew of the informant was sitting under a tree with some of his friends. A group of persons, including the present petitioner, attacked him, the result of which he sustained grievous injuries. Where the for the petitioner submits that as per the government's own version, he saw one Shanu Das Chaudhary fleeing from the scene, carrying the blood-stained dao. And it is further submitted that the said Shanu Das Chaudhary is the son of the present petitioner. So further submitted that stated that he saw the petitioner at the place of occurrence. Petitioner was arrested on when?
On 8/9/2025.
25 and has now spent 78 days behind bars. Petitioner who is aged 59 years. Huh? It is expected that the investigation of the case would have progressed by now, and having regard to what has been stated above, further detention of the petitioner is not. Accordingly, the prayer for bail is allowed. Conditions.
The restriction of CGM Sribu.
May I please, your lordship?
Hearing
Your lordship,
case that is not received to them.
for 56 days, your lordship, he is in custody. Earlier it was rejected, your lordship. And the allegation is sitting and forgery.
only 49,999 rupees was credited in the bank account of the petitioner from the account of the informant, Your Lordship. But the fact is that after receiving the said amount, the petitioner made complaint before the
We had
bank.
already seen the case diary earlier and
Yes,
checked
yes,
it.
But now today, Your Lordship, I am only considering the length of detention, Your Lordship. 56 days, Your Lordship, he is in.
56.
60 days offensive hearing, Your Lordship.
Friday, my lord. Friday.
60 days offensive. Your Lordship.
Actually, you see, it is, I think it is his material is already reflected
I am not
the order.
It's the detention part, Your Lordship. And apart from that, Your Lordship, the wife of the petitioner, she has been suffering illness, Your Lordship.
But charge sheet is not submitted.
Not submitted, Your Lordship.
Friday, 60 days will be over. Admin council for- Oh, page 24, huh? Or 31, 10, 25. There are 1, 2, 3. Yes. Bill application being bill application number of 2025 rejected by this court by dated 31/10/5 after perusal of the CD. Is submitted by learned counsel for the petitioner that petitioner has already is in custody. Statutory period of detention in the press. An additional PP prays for further time to produce the CD. But by that time, the statutory period will have been over. Length of detention. Fact that by now the investigation of the case so will have progressed. The prayer for bail is allowed. To say it is conditions. Satisfaction of
CGM Darong Mongol. Hello.
My learned friend was asked to take instruction whether charge sheet is submitted or not.
Charge sheet submitted, my lord.
96 days, my lord. The allegation of my lord ATM, my lord.
Charge sheet submitted in the month of August itself, my lord.
Page 7, my lord.
So what, call for the TCR?
Only, my lord, the attempt, my lord, considering the, my lord, nature of allegation, my lord, may. Second day, my lord, he is assertion.
The FIR is very cryptic, just, no, there is no description of any sort there. 90, how many days?
96, my lord.
Right. Let him go.
Time is, my lord, night 2:30 PM at night.
Huh?
Time, my lord.
Huh.
That was a relation, my lord, therefore.
Which way looks like something like that. Internet counsel for the petition, additional petition. Then application under so and so. Allegation against the petitioner is that he entered into the house of the victim and attempted to commit rape upon her. But dead when she shouted terror. And additional people submits that charge sheet in the case has already been filed in the month of August.
By charge sheet number 86/2025, dated 29/8/2025.
Full stop terror. In regard to the nature of the allegations and fact that the investigation and also the fact that the accused has been in detention for 96
days.
6 days. Further detention is not considered necessary. We pray for bail. 50,000 one surety satisfaction of
Jurisdictional magistrate, my lord.
Diploma. 25, my lord, case diary call for not received.
But my lord, I am in behind the bar, your lordship, 48 days, your lordship. 48 days I am behind the bar, your lordship. So my lord, kindly come on page number 16, your lordship, providing report, your lordship. The relevant portion is 17, my lord. Yes, 17, providing report. Last portion, your lordship. Notice under section 35(3) BNSS could not be served, my lord. So my lord, I am not served the notice of under
which
section.
page? Which page?
My lord, 17. Page 17, bottom, my lordship. So my lord, as per the Supreme Court judgment, your lordship, Satyendra Kumar until versus CBI 2022 10 SSC is not complied, your lordship. But the length of detention and my lord, notice has not been served, so I may be gone there, your lordship. Any condition may be. And in this case, my lord, I am totally not involved, your lordship. I was the temporary driver, my lord, and permanent driver was Islam Ali, your lordship. He is also behind the bar, still there. Actual fact of the case, your lordship, case number 4, my lord, I am categorically stated. As per allegation, my lordship, it is true I was hired as a temporary driver, but my lord, after some time, my lord, on the same day, I was asked to hand over the vehicle to the permanent driver Islam Ali, your lordship. Thereafter, I hand over the vehicle to the Islam Ali. Thereafter, this incident was occurs, your lordship. My lord, I don't know whatever behind the allegation, your lordship. My lord, an interesting part is that, your lordship, the date of occurrence is 30/9/2024, but FIR was lost on 4/11/2024, your lordship, after 35 days. And also, my lord, on the same day, vehicle was lost, but still dead. As per my information, your lordship, no FIR has been filed by the owner Nazrul Islam. Paragraph 7 and 8. I have sub.
Page number 22, my lord, so page number 20, my lord, of the bail application. Trial court rejected his bail application earlier, my lord, the basis of the materials collected by the IO, my lord. Page number 26, paragraph number 6, my lord. Down.
Right, my lord, considering this aspect of.
This is from Sansari case, my lord, that may be fixed, my lord, we'll produce the case there.
This is the only the first day.
First day, my lord.
First date, yeah.
All right, but is he behind for 40, about 45 days?
48
48
days.
days,
As on
lordship.
today, my lord. Next
So
week,
you'll
any
have to
day.
get it immediately.
Next week, any day.
Idea, lord, sanctuary, so short date may be given.
Monday, my lord, Monday. First December.
All right, Monday.
Master blessing.
Wait, please, your lordship. This is the second bail application, your lordship. I'm behind the bars for the last 52 days, your lordship. The allegation is that a person was beaten and he died. Only on the length of detention, your lordship, and the other accused persons are granted bail by this honorable court, your lord.
How many days?
52 days, your lordship.
By
But
calculation,
this is a 90-day offense.
it is offense, my lord. Specific allegation is direct implication is not there, my lord, but they were present, my lord. Who assaulted, my lord, that is not clear from the, my lord.
What is the name of the present petitioner?
Person Baspor, your lordship.
Earlier it was submitted, there is incriminating material against the present petitioner. This is why bail was rejected.
Us who represented on.
Mr. DP Goswami.
ইয়াতে থাকিব দাদা
DP Goswami PP submits post-mortem report reveals multiple injuries on the person of the deceased, and there is also incriminating material against the present petitioner regarding participation of the present petitioner in the alleged assault on the accused.
During the length of detention, your lordship. On any stringent condition, if your lordship.
When is 60?
52 days, your lordship.
Well, if you say there is no incrimination, I'd learn it, Mr. Learned counsel for the petition. Additional people. Page 21, order dated 7/11/25, huh? 1, 3, 4, 5, you write. submitted that petitioner has spent 52 days behind bars. He granted bail on ground of length of detention. It appears CD that the investigation has pressed in regard to the period of detention undergone by the petitioner. Further detention may not be warranted in the facts and circumstances. Therefore, bail is allowed.
Oblige, Your Lordship.
50,000 once you.
Same case, Your Lordship. Yes, different petitioner.
Same petitioner?
Different petitioner, Your
petitioner.
Lordship.
Present, my lord, in the group, my lord.
But no direct implication.
Was assaulted by, in fact, my lord, he was assaulted by several persons, my lord. Yes, my lord, directly seen, my lord, who was assaulted.
The same order.
I'm very grateful, Your Lordship. Oblige.
Wait, please, Your Lordship. So here the petitioner was arrested, my lord, on 11/6/25. Thereafter, my lord, charge sheet has been laid, my lord, citing 7 number of witnesses, and charges were also framed, my lord. But till date, my lord, the witnesses didn't get. And the next date is fixed on 29/11. Sorry, 8/12. Next date, 8/12. For evidence. Lordship may have a look at page 15, my lord.
Page?
Page 15, my lord. My lord, grounds of arrest number 3, my lord. Arrested accused Jonah Bali, my lord. Jonah Bali is before your lordship. And so, along with another 2, committed the crime using the vehicle Maruti Suzuki Baleno so. The vehicle used in the crime was recovered from the possession of Jonah Bali.
Your
The
statement-
dockety, my lord, amounting to 1,500 rupees.
In the statement of Jonavali Lordship, she stated that I, along with the other co-accused Lordship, abducted the people and took money from them.
Amount involved is 1,500, my lord.
Your name is?
My name is Jonah Bali, my lord.
Jonavali.
Page 15, first paragraph, my lord. Page 15, first paragraph, my lord.
Yes, what is there in the CD?
Statement.
Is
Lordship.
TCR, my lord.
Yes.
It is 168 days, my lord, today, my lord. Trial yet to begin, my lord.
Some
I'll
witness
say-
be examined, Lordship. Witnesses may be examined.
No, not examined. I have the certified copy, my lord. Witness not yet examined, my lord. Only charges were framed, my lord. Well, the charges were framed on, my lord, 6/11/25. And the next date is fixed on 8/12 for evidence, my lord.
What is the statement of the victim? Victim, which is here.
Admittedly, my lord, we have taken 1,500 from his pocket, my lord. Can I place the last order of the court below, my lord?
Yes, yes.
Order 9.
Yes. So 310. 2.
Paragraph 2, my lord, the facts of
Charge
that-
has been framed under 310.
Yes, my lord, yes. I will face the trial, my lord. Length of detention. Some medical treatment is also required.
This was rejected only on 15/11/25.
Not ours, my lord. The bail was rejected. So far as concerned, Raja Ali Rekibuddin Ahmed, my lord. Not me, man.
What about you?
I have not moved mine there. I have not moved mine.
Then
As because I have came here, my lord, I have not moved mine.
same reasons apply.
That's true, my lord. On the length of detention, my lord.
They also have the same length of detention.
Yes, my lord, same, my lord. 168 days, my lord. We'll face the trial, my lord.
Let some witnesses come. His learned additional session judges rightly alleged, very alarming.
Yes, my lord.
It may be 1,500 rupees, but a person going on his cycle to buy vegetables, you snatch him away, take him in your car, and 1,500 because that was the only money that was with him at that
That's
time.
true, my lord.
Had it been 50,000, would you have left it? Third learned counsel for the petition. An additional PP, this is an application under students. PCR as called for has been received. It appears that pursuant to the charge sheet having been filed, charges against the accused persons have been framed under section 310 within brackets 2 BNS by order dated 15/11/2025. By the said order, bail applications filed on behalf of co-accused persons was rejected by the learned additional session judge. Upon perusal of PCR in regard to the gravity of the, I am not inclined to grant bail to the accused persons at this stage. Therefore, bail stands rejected
At this stage,
at this stage.
I'm obliged.
Basically, we have received the case today, but updation is required, but that updation that we have not received, Lordship. I have communicated with the IO. Yes, the IO is transferred, that's why the new IO is appointed, so fix it next date, Lordship, we have sent back the CD for updation again, Lordship, and received the case, the statement of the one petitioner after getting in time, Lordship.
The last date you have not sent back.
Yes, it was taken back, but I was transferred, which was transferred, and the next I was appointed, that's why updation is not completed, Lordship. So one petitioner's statement is not here. I have telephonically communicated with IO that
Up to date case diary is not available, submits learned additional PP. Hence list the matter again on so and so.
the interim may be extended.
Interim order passed earlier.
9/12.
Continue till the next date fixed.
Item 31.
Did you receive it?
My lord,
Is already received.
but on some other day may be taken up, my lord. The senior counsel respected SRS.
The prayer of learned counsel for the petitioner, list the matter again on so and so CD. Receipt may be retained.
Hearing may be continued.
Passed earlier, continue.
Item 32 and 33.
Yes.
We have please, my lord. My lord, item 33, lordship, item 32 is, lordship, arising out of item 33, my lord. What happened, my lord, in this case, my lord, one, my lord, Daniel Hogg, my lord, was the lordship tenant of the petitioner, lordship. He has filed a written complaint before the police station, lordship, Neelam Bazar police station, lordship. And the said case was registered, made JD entry, my lord. Thereafter, the police, lordship, went to the house of the petitioner to inquiry the said ZD entry, my lord. Thereafter, lordship, allegation against me is that, lordship, during that time, lordship, I made a hot argument, lordship, with the police, my lord. That is, lordship, I'm before you.
Item 30. 32, let's see, case they received 32 PS case number Neelam Bazar 14225. That is not received.
32 is not received.
32 received. And 33, which was Neelam Bazar PS 14025, that is not received.
These are cross cases.
Not cross cases,
No.
same
Not
person,
cross
against same person.
On the basis of ZDNT, my lord, that case was lodged also against me, lordship. Can you see the FIR, my lord? Item 32, can you see the FIR? FIR is page, my lord. 15, my lord. Police lost the FIR, my lord. Page 15, my lord. Item 32. Allegation against me, Lordship, is that Lordship, I have also obstruct the police person from his duty, Lordship. I mean interim, Lordship.
He's interim, but his statement is not
My
here
lord,
recorded.
My lord, my statement recorded on Lordship, this month, Lordship, 2nd of November, Lordship. Both the cases, Lordship, statement have recorded, my lord.
Not in the case diary, but sufficient materials are there, Lordship, apart from the police personnel, there are independent witnesses there who implicated the petitioners. Yes, they have obstructed the police personnel and tried to assaulted the police personnel and tried to kill them, Lordship. Somehow, and the co-accused, one of his brother, Lordship, the petitioner's brother, Amir Khan, he also admitted in his statement, Lordship, my brother started attack the police party, who obstructed the police team from performing their lawful duties.
My brother was arrested, my lord, and this honorable court has already granted bail in motion state, my lord. There was, my lord, total 9 police officers, police personnel. I'm only one and my brother, Lordship. Is this possible to obstruct that person and threaten to kill, Lordship, this police person? What means I have?
And some injury part was there, Lordship, one Vishal Kathar, and they have stated that in their statement, Lordship, that Amir and Selim attacked Vishal sir with an intention to kill him. Though it was
No, but if they had appeared pursuant to any interim order, their statements
only his statement is not here, Lordship.
not here.
Not here. The CD is update on 18/10/25. It is after interim, what was interim granted on 19/25.
So we get the updated CD. In any case, the other case CD is not there.
It is not there.
My lord, other cases, all the sections are already, my lord, can you see the sections are available, Lordship, I think, Lordship. Bail numbers are PS 140.
If there all the sections are available, how is the AB maintainable?
My lord, thereafter, Lordship, before that, Lordship, case has been filed, Lordship, before register of the case, Lordship. During the time of GD entry, I have filed this case. Against the GD entry. Against the GD entry.
If no non-bailable offence is there in item 32, we dismiss it.
No, my lord, item 33, my lord. Item 33, my lord.
33.
Yes.
No bailable, non-bailable offence.
Section, my lord, 61 to 3.
You who is saying?
Section.
Section 61 to 329(4), 296 and
Lord, I have appeared in both the cases, Lordship. My statement is recorded, Lordship. On 2nd of November, my statement is recorded in item number 32 and 33, 15 of November.
Call for the updated CD.
Submission regarding item number 30. Earlier engaged as may not. The petitioner earlier engaged as may not in these cases.
The name of Mr. So-and-so.
Yes, sir.
Give the name. Be shown in the cause list.
In
which item? 32?
Both the item.
In what cases you write?
1612.
My lord, interim may continue.
Interim order passed earlier to continue.
1612.
34.
Look, though. This is a pre-arrest bail application, Lordship. FIR at page number 9, Lordship. It was called for, Lordship. It received. Lordship, basic allegation, Lordship, may I read the FIR, Lordship?
It is received.
It is received.
As for humble submission, Lordship, there is a relation between the victim and the present petitioner, Lordship.
Yes.
What? You know, 180 statement. Kindly peruse both the statements, Lordship, 180 and 180.
So generally we have to rely on the statement made before the magistrate, Lordship, 183. But
The utter
I see-
contradiction.
Yes, she refused for medical also.
I'd learned counsel for the pit. I'd learned additional PP. Application under so and so. Affected in the FIR is that the petitioner forcibly took the informant, who is a married lady, to the shop of another person and committed rape upon her. Perusal of the statements of the victim by the IO, by the same are found to be wholly contradictory to each other. Above, the possibility of false implication appears to be very much present. Regard to the above, the clearest bail. Provided that in the event shall be released on prior's bail of rupees 3,000 with one surety. Satisfaction of the arresting officer in connection with the aforesaid case. It is further provided that it cooperate with the investigation. Petition stands.
I'm over.
Certified lordship, we have received the case diary, but after getting interim lordship, petitioner's statement is not in the case diary, so up-to-date CD is required to see. We have to send back the CD for updation. Lord.
Up-to-date CD is not available. List again on so and so.
12/25.
Hearing order passed earlier, continue. Till the next date.
Oblige, your lordship.
So on last occasion, my CD was called, and after getting interim protection, my lord, petitioner appeared before the concerned IO on 12/11/2025.
Yes.
Our statement recorded lordship is implicated, but promised to marry, he has made medical relations with her thereafter a child was born. But he simply denied his statement lordship. Statement recorded, he has appeared before I.
Order dated 10/11/25. 1, 2, 3. CD as called for has been received. Appears that pursuant to interim protection granted by this court, petitioner has appeared before the IO and his statement has already recorded. Regard to the above is the nature of the allegations. Till detention of the interrogation of the petitioner may not be necessary. The order of pre-arrest bail dated 10/11/25 is hereby made absolute. Same conditions.
Must.
Petition stands allowed.
Here the petitioners are on interim lordship, and as per my instruction, they appeared before the investigating officer. FIR, your lordship will find at page 10.
Yes, what is there?
Yes, he has implicated his and the petition number 1, Manzila Khatun. She forced her to make physical relationship with her with the petitioner number 2 lordship. Thereafter, they have with blackmailing, they have frequently made physical relationship.
Application is made after 1 year. Applications made that after 1 year, till 1 year it continues. No hearing raised, no nothing was reported to anyone.
Passover statement. $35-year-old lady.
And witnesses are stated that if there are any illicit relationship between the victim and the petitioner, they have not aware of that fact as per the statement of the witnesses.
They are not.
As per the statement of witnesses, if there is any illicit relationship between them, they have not aware of all the fact, but the incidents are heard about them. They've heard about the facts.
Okay. Heard. For the petitioner also heard additional some application under so and so against the petitioners, comma, inter alia, involves outraging the morality of the informant, using her to have an illicit relationship with the petitioner number 2. Order dated 4/11/25. CDS called for has been years that fire has been lodged almost 1 year after the alleged relationship between the illicit relationship between the petitioner number 2 and the informant, lady aged about married lady aged about 35 years. Submitted that there exists political rivalries between the parties. They have appeared.
Yes, they have appeared.
Pursuant to interim protection granted by this court, appeared before the IO, and their statements have also been recorded. In regard to the above as well, material available in the prior's bail is allowed. Interim prior's bail dated 4/11/2025 is hereby made absolute. Added that the petitioner shall continue to cooperate with the investigation and shall not hamper the investigation or tamper with the evidence. Accordingly, sandbag.
Obliged.
That's the previous in Lordship. FI that page 16. It was called for.
You received the case there.
Lordship, the allegation was of taking some money from the beneficiary during survey of the Awas Yojana, Lordship. I'd like to point out the materials, whatever the allegations, in page number 20, Lordship. Line number 4 and 5, Lordship. This is the only this implicating materials against me, Lordship, during inquiry.
Page 20.
Page 20, line number 4 and 5, Lordship. They have examined 7 witnesses, Lordship. In page number 19, it is evident, Lordship. 7 witnesses.
Line number starting with
4th line.
Read.
The villager at CL number 7 stated that Shamsul Haq, TC, demanded bribe from him and he paid rupees 500 in cash. Only that much, Lordship. They in page number 19, Lordship will find that 7 witnesses they have examined, the inquiry committee, Lordship. 7 witnesses, Lordship. Rezia Begum, Mahbub Ali, Selim Ali, Sahnur, Ainul, Mintu, Pradeep. They have not stated anything against me. Although the number 6 witnesses said that I demanded rupees 200 and I misbehaved him, he has not paid to me, Lordship. Only allegation is only from 4th and 5th line, Lordship. That is in respect by the
witness Pradeep Deka, Lordship. Lordship, I am a local person, Lordship. I will cooperate with the investigating agency. Lordship, my custodial detention may not be required. My humble submission, Lordship. I will abide by any condition of the court.
Yes, PP.
To record me.
So, examine lordship, they have stated that yes, this petitioner along with another person, and earlies, they have demanding and collected money from several persons for the beneficiaries.
All the witnesses have implicated.
Yes, here lordship 7 or 8 witnesses.
No, me, against me.
3 witnesses were examined his name, but money was paid to the other person, earlies demanded by this petitioner lordship. One is Mintu Deka, he is stating that Samsul Hussain, Samsul Haq, lordship. He is demanding money, he has given 200 rupees to him, lordship.
200 not paid.
A statement of
In the inquiry report, says he did not pay him any cash after being misbehaved to it.
But he had in the statement that to দিব টকা খোজা পইচা অসুবিধা দুদিন দেৰিকৈ দিম কোৱাত ঘৰৰ নাম কাটি দিম বুলি ধমকি দিয়ে ৰূপাইবিহীন হয় 200 টকা মই দিব লগা হয়. That is the statement of the one of the witnesses lordship. Only thing is the conduct is very bad lordship, but one thing is I am my submission lordship that 400-500 rupees for a poor people is very precious for the poor villagers lordship. The beneficiary is taking.
Lordship, the legal point of view also, Lordship, the notice is also not being served by police, Lordship, under section 35, Lordship. And I will assist, Lordship, the investigating.
This is an AB.
Yes, AB. Whatever, Lordship, till then the police has not issued any notice to me also. Lordship, I am ready to cooperate with the agency, Lordship. All the witnesses, Lordship, as per the inquiry report, Lordship, the other witnesses have implicated the other person, Lordship. Me, only one witness, Lordship.
Earlier also rejected by additional
by
question judge
Lordship,
on
yes,
finding
Lordship.
sufficient material. How can I say there is no material?
No, Lordship, this, at that time, it was Lordship 411, Lordship. Now sufficient investigation has already been progressed, Lordship. I believe, Lordship, they have already examined all the witnesses, Lordship. And I
That is
am
why,
at that time, Lordship,
in
it was
regard to the nature of these kind of allegations, it's
at that time, Lordship, it was before the session.
amount itself
it was
is not that
initial stage,
important, but
Lordship.
what is going on sends a wrong signal to society.
Being a government servant, he's a tax collector.
Lordship, I will stand trial, Lordship. I will abide by any condition, Lordship. At the time of rejection, Lordship, it was the initial stage, Lordship. And at that time, the investigation was not in progress. Now, Lordship, I believe the investigation has progressed and they have already recorded the statement of the other witnesses. I am also ready to cooperate the investigating agency. I may be directed, Lordship, to appear before the IO to record my statement.
Only thing my humble submission before lordship granting
Any condition.
granting anticipatory to this please not lordship inspired other persons to do so. Such type of activities against the poor
That is what it sends a wrong signal
lordship.
in this kind of cases, corruption cases. Mr. Counsel for Deputies. An application under so and so. It appears from the fire that 10 allegations were made against the petitioner. What are you?
Shamsul Haq, Lordship.
No, what is your
Tax collector.
Tax collector.
Who is a tax
CC.
collector? Under
Gaon Panchayat. Lordship,
Kamrup, under which Gaon Panchayat?
Los Gaon Panchayat, Lordship.
Lof.
LOCH, Lordship, Los Gaon Panchayat. Under Bidia Jaikona Development Block.
Of being involved in collecting money from beneficiaries of Awas Plus 2024 survey, AWAS, conducted at the state Gaon Panchayat. The said affair was lodged by the Chief Executive Officer, Kamrup Jila Parishad, pursuant to which an inquiry was conducted by the Deputy Chief Executive Officer as well. The said inquiry of the witnesses had implicated the present petitioner of having demanded and received bribes of the CD himself indicated the present petitioner demanded and got bribes in connection with the scheme. Having regard to the material and the allegations. It case for grant of pre-arrest bail. Accordingly, petition stands.
All right.
Please.
Any intimation regarding service? No.
But we have not received any instruction.
Respondent number 2. And appears for the petitioner as per office note, 3 numbers of unserved notices have been received back with postal remark within remark 1, vernacular language illegible, 2, unclaimed, and 3, unclaimed. Is the meaning of unclaimed? Will claim.
This is Moharadpur, Sitapur district, Suraguna, Chhattisgarh.
Is the matter again on give it 2 weeks.
Item 44.
Well, 44, I have been appointed the amicus.
It's for bail, my lord.
My lord, what I was proposing, my lordship can take up the main matter for disposal itself. Because I've gone through the record statements. It does not meet the standards, my lord. Then and the statements of the victim herself are not doesn't inspire any confidence. That apart, my lord, the other evidences, my lord, the other PWs are all hearsay. They have no value. And medically also, my lords, there's no sign of injury, nothing.
In jail for last almost 1 year, man, 350.
The main matter for disposal some other day.
Well, this is
I am, my lord,
what
they
do
are
you
pressing a bail.
For suspension, madam. He is in jail.
Where is your eye?
IA 765, madam. It is there, madam.
This is the main appeal.
I'm in jail for last almost 1 year, my lord. Only 3-4 days left, my lord. And basically, my lord, the PW1, the informant, the father, my lord, his statement is that he doesn't want to proceed with the case, my lord. That is the statement. And out of apprehension, an FIR was lost. There has gone somewhere with this. And there is only a radiological medical report, which is of 17 years. And your lordship applying the law of the Darnell Singh, my lord, 2 years also come, then it is above that. And her statement is also not inspiring, my lord. She says that she stays at grandmother house, then again says she went with him. Too much of contradiction and, my lord, exaggerated, my lord. If the lordship one, I will.
What is the sentence?
My lord?
10 years.
Sentence, my lord, fixed tenure, my lord, 10 years, my lord. My lord, that is the thing, my lord, and he is a young boy, my lord. At that time, he was only 25, my lord.
Instead of this IA business, the main case can be taken. Because normally what happens, my lord, these kind of cases after,
Yes.
I'm not saying anything to him, but in this kind of cases, after, my lord, bail has been granted, this petition keeps on pending. And maybe in 2035, it will crop up.
At the same time, there is a limit to how many petitions we can dispose of.
My lords, not today, my lord, some other day.
Lordship may allow the IM, my lord, on the condition, my lord, that in the event I am, my lord, appeal is against me, then I will.
Since you yourself concede that the evidence is rather
Evidence, my lord, the
of a
and my lord.
standard that is not desirable, then what is there
And
to be
even
done? Okay,
the-
we'll pass orders on the IA today.
My lords.
He is in jail, my lord, that is the thing.
Next.
I'm deeply obliged.
May it please your lordship. As per last order, my lord, lordship 3010, lordship, they were supposed to file an additional affidavit. They have filed we have received the copy of the additional affidavit. However, the same is not on record, my lord.
The additional affidavit
Has been filed, but
has
it's
been
not come on.
filed by the respondent, but same is not on record. Release the matter again. On so-and-so registry is directed to place the additional affidavit on record.
My lord, we have an interim order, my lord.
Same order passed earlier to continue the next date of list.
My lord, date may be fixed.
Yes.
Give it date, second week,
17th, my lord.
17th.
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 17th of
17th.
12th.
12.
Much obliged, my lord.
Much obliged.
Much obliged.
Yeah, please, Your Lord. So here we have filed our affidavit, Lordship. Our affidavit is only regarding the proceeding that has taken place, that is for the court below. But Lordship may kindly have a look into the order dated 27/10/25 passed by this court, Lordship.
Order dated
27/10/25 passed by this court, Lordship. actions was called from the respondent state, but nothing as such has been filed by them. Because here what happened, despite the stay order, the charge sheet has been filed, Lordship. That is the bone of contention of this IA. He is respondent number 2, he is just a formal, he has got nothing to do. He is the informant only. In IA, we have
What is the additional affidavit about?
additional affidavit is about the proceeding that is taking place, Lordship. It was fixed today also. The proceeding has been kept in abeyance and it has been extended till 16/1/2026 because of the pendency of the IA before your Lordship. The IA that is 1077, we have filed, Lordship. 1077, we have filed intimating this honorable court that despite the stay order operating, the charge sheet has been filed by the state respondent.
Yes, what is there to say now?
Let the respondent clarify, Your Lordship, why charge sheet has been filed, because there is a Supreme Court judgment that if there is a stay operating, then no charge sheet shall be filed.
Where is the order of stay?
Lordship will kindly come first to page number
3518.
page number 12, Lordship, of the IA 1077. Annexure A, Lordship. 3/5/2018. Till then, further proceeding of the aforementioned Kokrajhar.
Till then means what? Issue notice returnable 4 weeks. So for
Lordship,
4 weeks.
We took steps immediately 4 weeks. Thereafter, Lordship may kindly come to page number 15, Lordship. It was last listed on 25/1/2021. After that, it has not been listed. That means stay order is operating till date. Till date, there is a stay order. And in the criminal petition, Lordship will be surprised. Till today, no affidavit has been filed.
In the criminal petition is about quashing.
Yes, criminal petition is about quashing of the FIR. No affidavit has been filed till date. The 2018 matter, Lordship.
Additional affidavit has been filed by you.
Yes, that has been filed by us. Bringing on record what proceeding has taken place on the last occasion before the court below.
Yes, you have anything to submit?
From a respondent.
You are not
Okay.
a respondent, you are respondent number 2, you are for the informant.
I will take instructions from a senior.
The state submit their affidavit, Lordship, why they have filed an charge sheet despite a stay order operating by this court.
To all that, we just say to proceed further.
Lordship will kindly look into when a stay order is operating, they are filing.
That is what we are saying, instead of taking an affidavit and all that lingering the matter, since it is quite evident that the stay order is operating, and we will say that further proceedings will not continue. That is all what is there.
Lordship, I shall be deeply obliged for.
Yes, prosecution, anything to submit? Apparently page 15, so interim order is in force.
121.
Hard learned counsel for the petitioner, also hard learned additional PP. Respondent number 2 is also presented by learned counsel. This IA has been preferred. A 1077, huh? Seeking appropriate directions in respect of the charge sheet number 47/25 dated 28/2/25, which has been submitted, allegedly in violation of the subsisting interim order dated 03/05/2018 passed by this court, suspending further proceedings in Kokrajhar PS case number 132/2018. It transpires from the record It transpires from the record that by order dated 3/5/18 passed in the connected criminal petition number 399 of 2018. This court had stayed further proceedings in the aforesaid case. Till returnable date and subsequently by order dated 25/1/2021, the interim order passed earlier was extended till the next date of listing, but the case was not listed thereafter. And hence the interim order was still subsisting when the charge sheet came to be filed. That is on. When is the charge sheet filed?
Lordship.
28/2/25.
Lordship.
There is no dispute that the charge sheet was filed despite the interim order passed by this court being in force at the relevant time. Full stop. Accordingly, it is directed that further proceedings pursuant to the charge sheet number 47/25 dated 28/2/25 in Kokrajhar PS case number 132 of 2018 shall remain stayed and further order.
I'm diplomatist, Lordship.
Highest and disposed of accordingly. Is the connected revision permitted to criminal petition for hearing.
In diplomatist, Lordship.
Remember for except is a territory.
For hearing item 4.
Right, Mr. Lopez. This case for questioning of the complaint petition filed by the Forest Department, my lord. The complaint is that annexure B, my lord, page 35. That is the complaint, my lord. It was filed on 2/3/2015, my lord. May I read, my lord?
Yes.
Complaint offense such as I have honor to inform you that 27/2/2015 about 7:30 p.m. a male rhino was killed using illegal firearms and also removed the suspected poacher or Gonabegu Pukon area under the Gopur. The legs, nails and tails, some fish were removed by poachers. The Osi Gopur police station, acting on the information reliable sources, interrogated 5 persons listed below to vehicle AS number such as Scorpio substitute dealer rhino horns and handed over to me on 1/3/2015 at 2:30 p.m. and they were brought to the safe custody Sunitpur East Division, Bishwanath Chariali. For the person here interrogated properly, they have been confessed their crime, came to the purchase the rhino horn. The statement was recorded under 58D of the Wildlife Protection Act 1972, amended up to date. The Ajit Gogoi, the forest officer, boring range in presence of me. The accused were arrested under section 50 of the Wildlife Protection Act 1972, amended up to date on 1/3/2015 at 11 a.m. Violation of section 39D, 44, 49B, read with 2 and 11 of the Wildlife Protection Act 1972, amended up to date, and the punishment under Section 51A to Wildlife Protection Act, amended up to the details offense report will be submitted soon. That is the allegation, my lord. But on first, my lord, the seizure report that they have given, my lord, there is nothing has been recovered from them, my lord. Nothing has been recovered. This is 20, page, lordship may see to page 26. That is the seizure report, my lord. Enclosed vehicle number, RC vehicle, RC of bike, etc. Pollution certificate, vehicle insurance number, RC wheeler, and photocopy of the affidavit, list of currency and cell phone, accused person. Since then, my lord.
What is the stage of the case now?
The case has been stopped. Nothing has been done since then, my lord. Henceforth, the case, my lord. Nothing has been done. Also, again and again, statutory is called for, and final report also asked for to submit, but nothing has been submitted till late, my lord.
Where is the
Lord, you
LCR?
may see the page 64, NHR H. It is 1360.
LCR to be. Page number. Status report says that IO has directed the police to arrest him. He is not arrested, so he hasn't filed final report. But accused was already in custody earlier
Earlier, they are in custody, my lord. They are released on bail.
for 56 days. After that, they were granted bail.
Yes, ma'am.
So where is the question of arresting them again? Is it necessary to arrest them to file the final report?
No, my lord, I am for questioning this the complaint, my lord. Because while I was serving, I already been retired, my lord. In the meantime, because of that, my lord, I am a police personnel, my lord. Of my all pensionary pension has been stopped, my lord. It's not, yeah, it is more than 10 years is there, my lord. Last order, Lashmi sees page 64, that is 13/6/2022. The divisional officer writing like that, the inquiry offense report such and submission of final report regarding. It is inform you that further investigation was such and such dated 2/3/2015 since long pending. You are therefore appointed as the investigation officer in respect of the above offense committed of Mangoni village under such and such 1/3/25. Copy of the preliminary offense report is hereby enclosed. For your reference, please carry out the further investigation of sense report and submit your final report along with the process of the offense owned by submission concerned trial court. I think nothing has happened as with the false case, my lord. So for 10 years, they had not able to file a final report, my lord. Nothing has been done. Divisional Forest Officer and asked to submit the status report and final offense, final report, my lord. Again and again, but he has not able to submit this report, my lord. Additional Chief Principal's Chief Conservator Forest Headquarters, my lord, writing to the divisional officer again and again, Shunitrish Division to submission of final report, my lord. But they could not submit the final report. Hence the case is pending. Because nothing has happened like that, my lord.
and nothing is required from them. So case is pending, my lord.
You were among the persons who were apprehended on that
Yeah, yes, my lord.
day, for these 5 persons.
My lord. We are in the car, they have been apprehended from road, my lord. Nothing is required for us, nothing, no allegation. They on suspicion that we are going to purchase something, but that is not fact, my lord. I am
Have you gone through the?
I have, actually, my lord, I have not gone through the, my lord, this year, my lord. If lordship permits me, my lord, day after tomorrow, my lord, when you fix it, my lord, I will go through, my lord.
All right, go through it, see if there is anything.
Yeah. Okay, if you have-
On the face of the FIR, there appears to be nothing, but
Yes.
after their arrest, if something has been recovered or anything, secretary has been.
27. 27.
Or 27. First week of December, my lord, any day.
5th of December.
Second December.
We have already fixed up to.
My lord, on
Last
5th,
week.
my lord, I have certain problem, my lord. On 3 or 2 or 3, my lord, I have no problem. Then, my lord, 8.
Right on 8.
8.
No, over hearing, wait. 8 to 9 or low items.
9, okay.
9.
And the additional PP 6 some time to go through the TCR
SLPP wale.
and is the matter again on 9th December.
Yes, sir. Problem, my lord. May it please your lordship. So by this application's lordship, the petitioners have prayed before this honorable court for quashment of the entire proceedings, my lord, which was registered under section 7 and 13 of PC Act, my lord. My lord, what has happened? There are 3 petitioners before your lordship. Petitioner number 1, my lord, is a platoon commander, my lord. He is a government servant. And petitioner number 2 and 3 are, my lord, home guards. They are not under statutory pay by the government, my lord. They are not government servant, in fact. What has happened, my lord? On 20 March 2018, my lord, may kindly come to page 23, my lord. This is the initial complaint, my lord, alleging that, my lord, the petitioner number 1 only used to collect money from the Jawans, my lord, on the pretext of, my lord, providing placements, my lord. However, my lord, along with the complaint, after receipt of the complaint, my lord, the Director General, my lord, forwarded the complaint to the OC Kokrajhar for registration of an FIR, and accordingly the case was registered, my lord. My lord, along with the FIR, the 2 money receipts were, my lord, annexed, which are at, my lord, page 27 and 29, my lord. Although, my lord, allegation is that the petitioner number 1 used to collect 2,000 to 10,000 from every Jawans, my lord. But along with the FIR, they have annexed, my lord, money receipts of rupees 100, my lord. Page 27 and 29 are the receipts, my lord. The receipts are issued under the, my lord, heading of All Assam Trained Home Guard Association. My lord, what All Assam Trained Home Guard Association is all about, my lord? My lord, may kindly come to, my lord, page 56, my lord. My lord, All Assam Trained Home Guard Association is an association, my lord, which is meant for the, my lord, purpose of providing financial assistance to the family members of deceased Jawans, my lord. On, my lord, 19/3/2017, which is at page 56, my lord, one general meeting was held of the All Assam Trained Home Guard Association, my lord. May kindly turn to page 56, my lord. First para, my lord. Today on so and so, a general meeting of the Kokrajhar District Committee of All Assam Trained Home Guard Association was held at the premises of Tulsibil Club under the chairmanship of the permanent president of the district committee, Mr. Sri Jiten Chandra Bormon,
following the agenda mentioned below, the following proposals were unanimously accepted by the meeting. Now, my lord, may kindly turn to page 58, which were the resolutions which were passed in the meeting, my lord. Point number 2, my lord, the rules and regulations are as follows. Number 2, to be eligible for financial assistance, the Home Guard Jawan must be a registered member by paying rupees 100 donation during the call out. Otherwise, the assistance will be denied. Number 3, the amount of financial assistance to be provided to the family of the deceased Jawan will be decided by the committee through discussion. So, my lord, the receipts which is annexed with the FIR, my lord, these receipts are with regard to All Assam Trained Home Guard Association, and the association was formed for the purpose of providing financial assistance. But on the other hand, the FIR says that they were collecting money on the pretext of, my lord, providing placements. My lord, there is nothing on record to substantiate that, my lord, the petitioners ever demanded any amount, or neither, my lord, anything was recovered from their possession, my lord. In fact, my lord, it will be very surprising, my lord.
What witnesses will say before the court?
But, my lord, when the end result is going to be 0, my lord.
How can you say end result is
For,
going to
my
be
lord,
0?
for doing justice to the accused, as well as for saving the precious time of the court, my lord, because there has to be something on record, my lord. They have annexed, my lord, receipts of All Assam Trained Home Guard Association, and the association itself, my lord, the meeting says that the receipts which are annexed are with regard to a biannual contribution. In fact, my lord, the resolutions which were passed, this meeting was, my lord, attended by, my lord, 385 members, my lord. My lord, may kindly turn to page 82, my lord. 56 to 82 are the signatures of the persons, all the home guards, my lord. They all the persons are all these persons attended the meeting, my lord. And as per the resolution passed in the meeting, my lord, the All Assam Trained Home Guard Association started to collect money, which is apparent from page 83, my lord. 83 to 116, my
We are
lord.
not deciding those questions of fact here. How can you say there is nothing?
My lord, there has to be
They
even
made a
the charge
complaint,
sheet.
the case was investigated, the statements were recorded. After that, charge sheet was filed, sanction was obtained.
My lord, that is
Then
true, my
it's
lord.
now for them to prove the case before the trial court.
My lord,
How
but
can you show there is absolutely no material whatsoever?
My lord, but there must be something on record, my lord.
On record means what?
No proof of demand, no proof of acceptance, my lord. Nothing was recovered, my lord. My lord, for attracting section 7, my lord, there has to be, my lord, demand from the public servant, and the same has to be paid by the, my lord, bribe giver. In the absence of any demand, my lord, in fact, my lord, the reason why the FIR was registered is, my lord, may kindly turn to page 31, my lord, kindly. On the basis of this, my lord, the FIR was registered. In fact, this is the original FIR, my lord. This was lodged by, my lord, district commandant. What it says, my lord, second para, in this connection and as directed by the Honorable DGCD and CGHG, Assam, you are requested to kindly register a case at your PS against Bolendranath Brahma, Platoon Commander, Urban Wing, Home Guards Officer, Office Koprajhar, and President Secretary of Association, for whom TC Brahma is collection money, and investigate the matter accordingly. And secondly, my lord, petitioner number 2 and 3 are not even public servant, my lord. Admittedly, they are home guards, my lord. Even the charge sheet says that they are home guards. My lord, what does the Home Guard Act says, my lord? I think there is a copy of the act in the case record, my lord, which was furnished by me, my lord. Section 15 of, my lord, Assam Home Guard Act and Rules 1947, my lord. It says, a home guard acting in the discharge of his functions under this act shall be deemed to be a public servant within the meaning of section 21. Acting in the discharge of his functions, my lord. My lord, act of collecting money on behalf of an association, which is meant for, my lord, providing financial assistance, that is not an official act either,
That is
my
what
lord.
you claim.
My lord.
That is your claim.
Yes, my lord.
We do not.
But this act says, my lord, this is not even not only my claim, my lord. Act says, my lord.
Your claim is that you were collecting money for the association.
Yes, my lord.
Yes.
No,
I don't know that.
This is even my claim, and even the FIR is supported with those money receipts only, my lord.
Other things may have been uncovered during investigation. How do we know? Because there is the order of framing charge.
No, my lord. Charge has not been framed yet, my lord. The case is at the appearance stage. Charge sheet is filed, my lord. Summons were issued to the accused persons. Immediately after receipt of summons, my lord, they appeared before they approached this honorable court. Charge has not yet been framed, my lord.
Yeah, so all these things you can argue at the charge hearing stage.
That is true, my
Because
lord.
the order of the special judge reflects that I have considered the materials on the case record statements of witnesses and find prima facie materials.
That is true, but my lord, the entire TCR is before your lordship.
Yes. Yes, prosecution.
My lord, there is nothing to substantiate, my lord, section 7 and 13 of PC Act, my lord.
Sufficient incriminating witness after the charge sheet is submitted, lordship. We received the PCR. This is to examine, sir, after the examination of the witnesses' statements recorded thereafter, charge sheet subject finding some incriminating materials, lordship.
That is what I am saying.
Even, my lord, the charge sheet is silent with regard to any incriminating, my lord, because the charge sheet I have annexed, my lord, page 37, my lord. Sorry, my lord, 35. Page 40 is the, my lord, facts disclosed during the course of investigation, my lord. 41, it starts, my lord. Even it says, my lord, from 41 line 3, my lord, from the first, if I read, my lord. During investigation, the complainant and witnesses were examined and recorded their statements under 161 by the previous IOs. PO was visited and drawn rough sketch maps of the PO and seized one register book of death fund, my lord, of All Assam Trained Home Guard Association. Even the charge sheet says, my lord, that, my lord, death fund register was seized. One more thing, my lord, may I kindly turn to, my lord. In fact, my lord,
You examine the matter. What is the, we'll take it up on another day.
We have go through TCR and the case diary received, lordship.
Yes.
We have to go through case diary and please another.
my lord, in that case, my lord, may I pray for, my lord, interim stay, my lord, till next date, because the case is fixed on, my lord, 10th of December.
We'll have it day after tomorrow.
Yes.
When is the next date?
10th of
10th
December,
of
my
December.
lord.
So before 10th.
10, 12.
10th of December. Then okay, fine. We can have it on first week of December then.
Ek tarikh. Ek bar.
Hard learned counsel for the petitioner. Learned additional PP6 sometime to go through the TCR. Hence, list the matter again on 1st of December.
Deeply obliged.